Committee on State Affairs will come to order. Welcome back. I'll pass the gavel to the Vice Chair as we continue to move through our posted agenda.
There we go. The chair lays out Senate Bill 1026 and recognizes the bill's author, Chairman Hughes, to explain the bill.
Thank you, Madam Chair. And members, Senate Bill 1026 has to do with the authority of the Attorney General to prosecute election law violations. Many on the committee are familiar, and many observers of this process know that the Texas Court of Criminal Appeals ruled in the Stevens case that, quote, the Attorney General is not required by law to prosecute election law violations, unquote. Went on to hold that Article 4, Section 22 of the Texas Constitution says the Attorney General shall perform other duties as required by law. But the Election Code does not require the Attorney General to initiate prosecution for an Election Code violation. Therefore, while the AG can prosecute with the permission of a local prosecutor, the AG cannot initiate prosecution unilaterally. That was the ruling of the Court of Criminal Appeals, enjoining a decades-old statute, and that's the law of the land today. And so, Senate Bill 26 would change the statutory may to a shall, would give the Attorney General the power to prosecute election crimes if no proceedings have begun on these crimes after 6 months have passed. Under this bill, local law enforcement that would normally submit reports of probable cause to a local prosecutor must also submit these reports to the Attorney General. And upon request of the Attorney General, the local prosecuting attorney or law enforcement must also turn over all information regarding their criminal investigations on these offenses. We are well aware of the situation where a local district attorney may be conflicted. A local district attorney that is elected locally and is being asked to investigate, to prosecute allegations of election crimes, at best could be in conflict, and at worst it could be more serious, and who knows whether politics or other matters in any given county could affect prosecution. So election law is a statewide matter of paramount statewide importance. This bill is intended to restore the authority the Attorney General has had for decades to handle those matters. And that's what the bill does, and I'll yield for questions.
Thank you, Mr. Chairman. Members, are there any questions for Chairman Hughes? If not, okay. We do have Jeff Barr here from the Office of the Attorney General as a resource witness. Members, any questions for the resource witness? All right, thank you. So, Jeff Barr. Thank you for being here. Introduce yourself and give us your testimony, I guess, or you just have some questions. All right. All right, so go on and introduce yourself, please.
Good afternoon, Chairman, Madam Vice Chair, members. Thank you. I am Jeff Barr. I am the Chief of the Election Integrity Division. I've been the Chief since late 2022. It's a prosecution-focused division that spun out of the Criminal Prosecutions Division.
Well, thank you. And Chairman Hughes, you're recognized to ask some questions.
Thank you, Madam Chair. Council, thank you for being here. Again, these matters are better known to some members of the committee than others, and many of the folks participating in these hearings and watching them have followed this closely. But for the benefit of all of us, will you help me walk through some of how we got here? Before the Stevens case, what was the process for the Attorney General's office to get involved in the investigation, prosecution of alleged election crimes?
Sure, Senator, thank you. For close to actually 70 years, since 1951, the Texas Attorney General has had concurrent authority along with state, county, and district attorneys to prosecute election fraud offenses in the state of Texas. How that would come about is the Attorney General's office has investigative peace officers much like a brick and law enforcement agency, brick and mortar law enforcement agency. Those law enforcement officers would go and investigate complaints of election fraud that might come from a request of a DA, might come from a request of a local sheriff. They would investigate that. Out of professional courtesy, they might bring it to a local district attorney for the option to prosecute. If the local district attorney was not interested, it gave, for whatever reason, it gave the Texas Attorney General the authority to go ahead and prosecute. And so therefore the AG's office did and does still employ prosecutors in the agency to prosecute those offenses.
And so that's the practice since 1951 you described to us, and I don't know if there was any much question about whether that was legally sound. It was done, and everyone relied on that. Then what happened with the Stevens case? Tell us how that changed.
In December of 2021, this issue came to a head through a writ of habeas corpus in a case that the AG was prosecuting.
Just in case, you're probably going to do this, but for the benefit of everyone listening, tell us what a writ of habeas corpus is.
A writ of habeas corpus is a proceeding in which a person challenges the constitutionality of their detainment, essentially.
So I've been imprisoned. I'm in custody based on an alleged violation of the law, and I say, hey, I shouldn't be here. Let me out. I file a habeas petition.
That is correct.
Go ahead, thanks.
And so the issue on habeas was whether the Texas Attorney General, in fact, had constitutional authority to prosecute without a consent of a local district attorney. The Texas Attorney General relied on Article 4, Section 22 of the Texas Constitution that has a clause that says, as part of his or her duties, they should perform other duties as may be required by law. Well, as I testified just a second ago, since 1951, the legislature has created a law that authorized, in fact, the AG's office to prosecute such crimes. So that was the clause, one of the clauses that were issues in this analysis with the Texas Court of Criminal Appeals. The majority of the justices in their opinion said, well, because the clause didn't say shall, because the statute didn't say shall in the statutes, it said that AG may prosecute. Therefore, that is really, we're just interpreting that to mean, well, that means if the local DA gives you consent. And in this case, the local DA didn't give you consent, and so therefore, you're violating separations of power.
So thank you. So that was the court's ruling. And so since that time, when there's an alleged violation of election law in Texas, if the local district attorney does not consent to the Attorney General's jurisdiction, what does the Attorney General's office do?
Currently, post-Stevens?
Yes, sir.
The local district, the Texas Attorney General's office is hamstrung to prosecute election fraud cases.
And so you've walked us through this very well, and explained it to us. As you read Senate Bill 1026, now we're not going to ask for an official position of the office on this legislation because we recognize the legislature makes laws and the executive branch executes those laws. We're not going to ask you for an opinion on whether this is a good or a bad idea. We kind of think it is. But tell us what the effect, you believe the effect would be if Senate Bill 1026 were to pass. If this were to become law, how would that change the procedures at the AG's office with regard to election crimes, as you see it?
Chairman, this bill does two major things. One, it creates an implied consent, meaning if the local district attorney, upon receiving a report, a law enforcement report establishing probable cause that election offense has been committed, and does not then proceed within 6 months of taking some formal action on it, then this bill essentially makes that a consent to prosecute to the AG. That's number one. Number two, this bill changes the statutory language from may to shall to meet the analysis set out of why the court said that we didn't have concurrent authority.
Okay, that's very helpful. So let me ask you this question. Regardless of whether Stevens was properly decided, many of us do not believe it was, but even under the Stevens opinion, if Senate Bill 1026 were to pass, do you believe the AG's office would then have authority to proceed on election crime violations in these cases when the local prosecutor has not done so within 6 months?
I believe the AG's office would have new language to go forward and prosecute crimes based on the analysis that the Court of Criminal Appeals has created.
That's how I should have asked the question. Thank you for that answer. Thank you very much. Other members may have questions. I don't want to monopolize the time, but anything else procedurally or legally that we haven't covered that you think this committee should know as you speak on the bill?
Nothing further, Chairman.
Thank you. Thank you, Madam Chair.
Thank you, Senator Hughes. Senator Birdwell, you're recognized.
Thank you, Madam Chair. Mr. Chairman, please forgive my arriving a bit late. So my question may be for you or for our, I'm not sure, but in reading the bill, there is a possibility that I don't think it contemplates. We understand that what we're trying to fix here is that a district attorney chooses for a partisan reason, maybe political and partisan, to not prosecute something. But if the same material, based upon the way the bill's written, from a law enforcement entity is submitted to both the DA and the Attorney General, on the chance that the Attorney General finds that material in a way that he agrees with the DA not to prosecute, this bill doesn't give the Attorney General the ability to concur with the district attorney and say no. It tells him you still have to prosecute, even if evidentiarily he might agree with the district attorney. So how do we fix that?
Yeah, Senator Birdwell, thank you for that question. You raise an interesting dilemma. It would be my interpretation as a prosecutor for over 20 years that shall does not erode my discretion to analyze a case and to prosecute. I read that to mean I shall review for evidence sufficiency, and therefore my ethical duties will prevail at the end of the day, and my oath will prevail if the evidence is there, and I can prove the case. Typically, prosecutors do an analysis. Can they prove their case beyond a reasonable doubt? Then I'll file. If I don't feel that I can prove the case, if the evidence is insufficient, I would argue that shall does not mandate me to prosecute against my ethical duties.
Well,
that is my hope, Senator.
right, I understand. What I think you've just said is what probably needs to amend the bill, because what happens, Mr. Chairman, the day that it's no longer a district attorney we have questions about their efficacy, but if someday a future attorney general we have concerns with. So I would think it would be appropriate for the attorney general to have to, I want that discretion that you've described, but I think it ought to be specified as opposed to implied, so that if some future day a district attorney doesn't do something, the attorney general reviews it, there's a requirement of some type that the attorney general has to say, here's why I non-concur and I'm going to prosecute. Right. Or here's why I concur and I'm not going to prosecute. Because to leave it implied means a future attorney general can just, doesn't have to get in the batter's box and take a pitch. You can just choose not to do something because some future day we might have a problem with the attorney general that we have with some district attorneys.
And Madam Chair, if I may, thank you. And I don't want to know what council
You're
thinks.
recognized, Senator.
Thank you, Madam Chair. Thank you. That's important. And I apologize for jumping the gun. And I want, subject to the chair's discretion, I want to see what council thinks as well. But Senator Bardwell, I hear you.
I'm thinking about the Minnesota Attorney General is the example I would give right now. So
Yes, sir. I would just say that because we are legislating while the Stevens opinion is still the law of the land, because as of the time it was issued, the Court of Criminal Appeals had authority to say what the Constitution means with regard to criminal matters. That's going to be considered this session. That may change, but while we're living in this post-Stevens world, it is important that there be a shall in the statute to get us past that. I know you realize that.
I want this, but I'm just trying to think through that if you have a law enforcement entity that says, I've got probable cause, but the district attorney didn't agree, and the attorney general agrees, we don't know how often that'll be, but that option, may not be a probability, but it's a possibility. That if the attorney general agrees with the district attorney, the law doesn't compel him to still prosecute.
No, Senator, you're exactly right. I mean, I'm sure there will be cases if this were to become law, and I'm sure there were cases before Stevens where an investigation takes place, and back when the DA and the Attorney General had concurrent jurisdiction, and they both agreed this is not something we're going to prosecute. You're right. We sure don't want to pass a law that forces the AG to prosecute a case where the evidence is not there, or whether for other reasons in their discretion they should not. And so as we think about this, counsel, if you're comfortable, as we parse the words, we don't have to write the amendment here, but do you think there's a way we can address this that doesn't deprive us of the shall, which we need to address the Stevens opinion, if that makes sense? You don't have to write it for us now, but do you think there's a way to thread that needle, or if it's necessary?
I think there is, Senator, and our office can certainly provide language in that regard.
All right.
Oh, thank you, Madam Chair.
All right.
Thank you.
Thank you, Senators. Appreciate it. Anyone else have a question for our resource witness? All right. Thank you. Appreciate you being here and helping us with this and helping us understand. You're excused.
Okay, thank you.
The chair now opens up public testimony and calls Andrew Hendrickson, Dr. Laura Presley, Veronica Warms, and Ken Moore. Andrew Hendrickson, Dr. Laura Presley, Veronica Warms, and Ken Moore. All right, let's see, Dr. Presley. She may be making her way down. Let's go on and get started. If we'll start on this side and just work across. Members, if it's okay with you, we'll just hear everyone's testimony first, and then we can ask questions after. Please introduce yourself and give us your testimony.
Thank you, Vice Chair Paxton, Chair Hughes, members of the committee. My name is Andrew Hendrickson, representing the ACLU of Texas, testifying in opposition to SB 1026. Respectfully, the layout, I think, really mischaracterized the Stevens opinion in terms of what the actual holding was, and focused on one very small part of the opinion about concurrent jurisdiction, for which the court actually made 3 points, and the required point was only one of the 3. Just to get into that a little bit, I will start by saying this actually goes back to not just Stevens, but a long line of cases, starting in 1974 with Ex parte Giles, and really specifically in this instance, in 1987, with the Meschel case, in which the court ruled that a speedy trial bill passed by the legislature interfered with the exclusive jurisdiction of county and district attorneys to file criminal charges in district court. And that is the key here, is that there is a separation of powers issue that the Fifth Circuit, the Texas Supreme Court, and the Court of Criminal Appeals on different occasions have said that that exclusive power lies with the county and district attorney. And therefore, without an amendment of the Constitution, there is no way to confer that power, required or otherwise, onto the Attorney General. As the court wrote in the Stevens opinion, if I could just pull it up here, the Court of Appeals held that the Attorney General should be allowed to initiate criminal processes because some duties imposed by the Attorney General are both executive and judicial in nature. The court goes on to say that we resolutely concluded at the end of this discussion, quoting the Saldano case that the lower court had relied on, that the Attorney General has no independent criminal prosecution authority. The Attorney General has no criminal prosecution authority. Rather, he is limited to representing the state in civil litigation. What this boils down to is the Attorney General cannot interfere with that specific grant in Article 5, Section 21 of the Constitution that says that the criminal district attorneys have the exclusive authority to file criminal charges that cannot be extended to the AG absent an express constitutional amendment allowing that to happen.
Thank you. Thank you for your testimony. All right. If you'll introduce yourself and give us your testimony. Thank you.
Chair Hughes and members of the Senate State Affairs Committee, my name is Veronica Worms, representing the Texas Civil Rights Project against SB 1026. Election fraud cases are exceedingly rare, yet this legislature is expanding the Attorney General's power to unilaterally go after any perceived election code violation in an end run around our highest criminal court's ruling, determining that that was a matter for local district attorneys to decide. Despite the 2021 ruling restricting the AG's unilateral authority to prosecute election fraud, his office has continued to aggressively pursue these cases on the taxpayer's dime, regardless of local law enforcement's ability and authority to do so themselves. This is just one more installment of the legislature's attempts to expand the AG's powers far beyond the scope of his duties and simultaneously take prosecutorial discretion out of the hands of local DAs. DAs would not be able to control whether or not a report of an election offense was eventually prosecuted, no matter how flimsy the evidence is. And contrary to the AG's office's interpretation, the language as written mandates prosecution of these cases. Aside from our concern of state overreach, another concern for us is the potential for legislation like this to call a chilling effect on voters, particularly those who are uncertain about their eligibility, deterring participation in elections. Safe and fair elections are of the utmost importance to both the public and the Texas Civil Rights Project. This is why we recommend improvements and investments in the Secretary of State's voter education program and fund, so that every eligible Texan hoping to participate in our democracy feels empowered to do so, instead of giving the AG more power to make voting scarier for Texans. Thank you.
Thank you for your testimony. All right, sir, if you would introduce yourself and give us your testimony.
My name is Ken Moore. I am for this bill, and I'm representing myself.
Can you move the mic a little closer to yourself there? Thank you.
My name is Ken Moore. I'm representing myself, and I am for this bill. As many of you already know, I lived in Harris County for a long time, and I was election judge there, and I saw a lot of things that happened. In 2018, I moved to Brazoria County before everything really started to get, all the fireworks really started to go off. But we had a lot of issues during that time. And in 2021, if you'll recall, there were a lot of bills passed in that session that depended on the AG's ability to move and act. And the Stevens case really turned the whole world upside down. And there are many efforts along the line to try to fix this. There were some efforts to pass legislation that would allow a prosecutor in adjacent county take up with the prosecutor in the county didn't want to do it. Senator Betancourt has the elections marshals and judges bill. He's been trying to get through the House, the Senate for he's gotten through the Senate several times, but hasn't gotten a hearing in the House that would address election crimes. And I think this time around, Representative Swanson has a bill that's about the same thing. But folks, the ultimate answer is going to have to be for the Attorney General to have the ability some way, somehow, to act. If you have local prosecutors who refuse to do their jobs and to prosecute these irregularities, then you're really against a wall. Ironically, the Stevens case helps highlight this because it was the local prosecutor that refused to deal with that case when the Rangers handed it off to them. And that's how it wound up in the AG's office. So I think this bill does go a long way towards fixing that, and I would urge you to move it forward.
Thank you. Thank you for your testimony. Members, any questions for these witnesses?
I'll go last if anybody. I'll go after everybody else. I've got a couple.
All right. Chairman Hughes, you are recognized.
Thank you, Madam Chair. I thank each witness for being here. I want to ask a couple of questions about the Stevens opinion because it certainly was not our intent to mischaracterize it. We want to be clear on what the law is, and then we can also discuss what the law should be. Do we agree that from 1951 until the Stevens opinion, the Attorney General had concurrent jurisdiction with prosecutors and did, when the office was held by various attorneys general, did initiate prosecutions of election law alleged violations?
I can agree that that statute was on the books for those years. I would say that it was unconstitutional under the Texas Constitution separation of powers doctrine in Article 2, Section 1 for the entirety of the time that it was in effect. As are many laws that are on the books for a long time, doesn't make them constitutional, it just happens to be when they get challenged.
And then, Mrs. Warren, anything else on that?
I would concur with my colleague, Andrew.
Thanks. And then if I may ask, the language in Article 4, Section 22, and it's, I'm looking to make sure we didn't quote it out of context. He shall, whenever sufficient, this is referring to the Attorney General's office. I'm reading the last sentence of Article 4, Section 22 of the Texas Constitution. He shall, whenever sufficient cause exists, pardon me, seek a judicial forfeiture of such charters unless otherwise expressly directed by law, and give legal advice in writing to the governor and other executive officers when requested by them, and perform such other duties as may be required by law. Please take my word that I did read that accurately.
That is correct, although I will just point to the portion of the Stevens opinion where they wrote, however, the other duties clause does not permit the legislature to assign to the Attorney General any duty without regard to the branch of government to which it attaches. Simply put, the other duties clause may not transform the judicial duty of prosecutorial power into an executive duty. Such an interpretation would exempt the Attorney General from explicit separation of powers limitation, and that was why that the court ultimately found the Brady decision that the lower court had relied on distinguishable in that case. The real crux here, I think, and this is really where we have to get at, is that unlike the separation of powers doctrine at the federal level, the separation of powers doctrine at the state level in the state constitution has always been held by the courts to be much stronger than the federal one, because for two reasons. One, it's explicitly stated. It is implied and it is read into the structure of the federal constitution that the three articles laying out the role of the legislature, the judiciary, and the executive create a separation of powers doctrine. Texas actually put it in word for word. And the second is that we do not have a sweeping clause anywhere in the Constitution that says any branch may do what is necessary and proper, as is in the federal Constitution. And the court has therefore ruled that exceptions to constitutionality, and this is the Texas Supreme Court and Financial Commission of Texas v. Norwood, exceptions to constitutionally mandated separation of powers are never to be implied in the least. They must be expressly permitted by the Constitution itself.
No, thank you. And I was going to ask, did the Stevens, and thank you for that, did the Stevens opinion make reference to the may versus shall question that we spent some time on this afternoon?
They did. In the section of the opinion about concurrent jurisdiction, it is the first point that they talk about how the may versus the shall does create some issue. Section B, then, which I read from a little in my testimony, says the above notwithstanding, and then goes through an entire analysis to say the above notwithstanding, that wouldn't change the fact that this is at the crux of the issue, a separation of powers problem, and absent an express grant, the shall versus may issue is not going to ultimately be controlling. That interpretation of the law would allow any shall to get the AG around the inherent and express separation of powers doctrine that is, so strong and has been respected for many, is long-standing doctrine in Texas. Texas Supreme Criminal Court of Appeals cases talk about that as far back as 1912, 1914, and a couple of opinions that laid sort of the groundwork for that interpretation.
I would agree with that. I don't have anything to add.
Well, thank you both. Let me ask, we talked about the 1951 statute, and you made a great point. Just because a law has been passed doesn't mean it's a constitutional law. let me also say, I'm going to avoid using the phrase, I don't think I've used it today, that the Court of Criminal Appeals struck down a statute, because a court cannot do that. A court can enjoin a statute's enforcement. A court cannot, I'm not lecturing you, I'm lecturing myself. A court cannot remove a law from the books, if you will. That 1951 statute is alive and well, still sitting there. Based on the current law, its enforcement is enjoined. That could change. But with that caveat, are you aware of other statutes currently existing, which may or may not be being exercised, where this separation of powers problem under the Texas Constitution is an issue, but maybe has not yet been raised in front of a court?
I'm sure I could come up with some. I can say that, you know, the one I think that has been struck down that is probably most controlling here, or most apropos here, especially because of the 6-month time frame, is actually probably the Meschel case, which had to do with the speedy trial law enacted by the legislature, which required a defendant to be brought to trial within 120 days. What the court said in that case is that unless broad legislative authority for controlling the Freestone County attorney's discretion in preparing the case for trial, and that they make it very clear that in preparing the case for trial, that is also in the exclusive jurisdiction of county and district attorneys, can be found elsewhere. The legislature has violated the separation of powers doctrine because we are not aware of any other constitutional provision expressly granting the legislature power to control a prosecutor's preparation for trial. We must conclude that the legislature, by providing for such a right in the instant case, violated the separation of powers doctrine. So when you're talking about the legislature even just stepping in and putting a time frame on the ability of when the prosecutor has to bring those charges, that has been held to also violate the separation of powers doctrine.
So not the Speedy Trial Act itself, but that application of the Speedy Trial Act with regard to the Speedy Trial Act is alive and well. I think you and I are both for it.
That iteration of the Speedy Trial Act, which is the current one, is different. But in the 1987 instance, it was that 120 days. And so, you know, the CCA goes on to say a prerequisite for the legislative power to act under Article 5, Section 25, however, is the existence of a right for which the legislator can provide procedural guidelines. Were it other, the procedural legislation would itself create a substantive right, right? So it is about the substantive right that can't be disguised as a procedural issue, and I think that's where the timeframes apparent in this bill are akin to the issues with that were identified in the Meschel case.
No. Thank you very much. Thank you, Madam Chair.
May I add something? Lisa?
Thank you, Senator.
May I add something, please?
Yes.
Okay. Just by way of context, and I'm not an attorney, and I don't have all the details in front of me, but I'd also remind you that in the original trial, the Stevens case, Judge Kevin Urey gave a strong dissent. And part of his argument was this whole thing had been litigated before, and he gave several examples where past cases had been talked about this. When the court reconsidered, Judge Michelle Slaughter, wanted to reconsider it because she wanted to see if there may be exceptions where the Attorney General would have power. And in both cases, they were overruled by the other justices. But there is, you know, you can't really say that there's unanimity among the experts on this whole thing.
Thank you. All right, members, are there any other questions?
May I ask? Go ahead, I'm sorry.
Well, so one of the things that happened while we were listening to testimony is that Dr. Laura showed up, so thank you. We're glad that you're here. And she has not given testimony yet. Does anyone have questions for any of the other witnesses? Would you like to hold them?
Madam
here?
Chair, I was just going to apologize, and I didn't mean to exclude you from that discussion, and thank you for reminding us about something very important in that opinion. Thank you very much.
Yes, sir.
All right, so the three of you who have testified, y'all are free to go. Thank you for being here.
Thank you.
And Dr. Laura Presley, I'm glad to see you. If you'll go on and introduce yourself and give us your testimony.
Yes, thank you, Senator Paxton. I'm Dr. Laura Presley, and I'm representing True Texas Elections, and we do support this bill, giving the AG these extra Make sure I'm on the right bill. This is the one for the
This is on 1026.
1026. So, okay, I think is this Creighton's bill?
No, this is Senator Hughes' bill.
Senator Hughes' bill, all righty. Yes, so fully support, and I would like to, I really want to speak on Creighton. I thought this was Creighton's. Okay. So fully support Senator Hughes. Thank you. That's it.
All right, thank you. Members, any questions for Dr. Presley?
Thank you. Good to see you.
Good to see you. All right. Is there anyone else wishing to testify on, for, or against Senate Bill 1026 by Senator Hughes? Seeing none, public testimony is now closed, and the bill will be left pending.
Thank you, Madam Chair. Okay. The chair now lays out Senate Bill 533. Senate Bill 533 by our colleague, Senator Sparks. The chair recognizes Senator Sparks to explain the measure. Welcome, Senator.
Thank you, Mr. Chairman and members. So, members, this bill would require an election for the issuance of bonds or tax increase to be held on the November uniform election date. Last session, we passed historic property tax relief, but many Texans failed to see any form of relief. One reason for this is that local government swallowed up much of that through increased spending and debt, often in the form of the issuance of bonds. Local governments will hold these elections in May, expecting low voter engagement. Some of these bonds have passed with less than 2% of total voters in favor. True representative government is achieved through an active, well-informed electorate. The decision to take on additional debt or to raise taxes should take place with an engaged public. It's pro-democratic and pro-good governance. With that, Mr. Chairman, I'm happy to take any questions.
Thank you, Senator. Members of the committee, any questions for the author? Very well. Senator Hinojosa.
Just a quick question, Senator Sparks. Wouldn't that also save us taxpayer dollars by not having to operate, run an additional election?
Yeah, in fact, I think we may have voted on a bill on the floor today where a local entity was asking for their normal elections to not be held in May, but to be held in November in order to try and save dollars, to save from an additional election. So yes, I believe it would.
Thank you. Great bill.
Thank you, Senator Hinojosa. Members, any other questions for the author? Thanks, Senator. We'll take testimony on your bill.
Thank you, Mr. Chairman.
We'll open testimony on Senate Bill 533. The chair calls James Quintero. And after Mr. Quintero, we'll open up public testimony. Anyone wishing to testify on, for, or against Senate Bill 533, please step just outside and register. You have plenty of time. Mr. Quintero, welcome. Get situated there, introduce yourself, and give us your testimony.
Yes, sir. Mr. Chairman, members of the committee, my name is James Quintero. I represent the Texas Public Policy Foundation. I want to thank you for the opportunity to address the body today on this common sense election reform. I'll be testifying in support of SB 533. In the ideal, bond propositions and tax hike elections would be decided at a time when the greatest number of people participate in the democratic process, so that whatever decision is reached more closely approximates the will of the majority. Now, unfortunately, the system we have in place today does not meet that standard. Instead, it permits massive debt to be decided by a relative few during non-peak election times. And I want to offer a bit of data to substantiate that point. As you'll see in your handout here, one of the things that I spent the interim doing is researching the May 2024 election cycle, and I collected data from different election notices, the Bond Review Board, and voter information documents. Now, the intent of the exercise was to better understand the actual amount of debt being considered during the May election cycle, as well as the number of voters involved in the decision-making process. And based on that analysis, I want to offer a few points relevant to today's discussion. First off, just setting the stage, during the May 24 election cycle, local governments offered up 325 propositions worth a total of $38.8 billion. Of those 325 items, voter approved 260 measures, which will ultimately cost taxpayers $33.3 billion in both principal and interest. Now, what's interesting about this is that the passage rate during the May 24 election cycle was 79.9%. That's actually a bit higher than in the November cycle, which was 73.3%. Now, among all of those items that were approved, many were passed by a relative few, and included in your document are the votes for and against each of those 325 items. Just noting a quick few, a couple that caught my eye was Banquette ISD's $86 million proposal received just 159 yes votes. Again, $86 million was approved by 159 yes votes. Elsewhere, the city of Donna's $114.7 million proposal received just 614 votes. Now, of course, those are just a few of the examples. There are many more in that handout. But what I hope all of this information does is illustrate the fact that large, expensive debt measures are being approved by just a handful of people in non-November elections. And I hope the body considers reimagining and reforming the current system so that we ensure greater public participation as well as community representation in the bond issuance process. So for that reason, I want to encourage the body to look favorably on SB 533, and thank you for your time.
And thank you for your testimony. Members, any questions for Mr. Quintero? Senator Hall.
Indirectly related to exactly what you're talking about, but changing the date so that you get more public participation. What your chart shows here, that when they post the amount of the bond, it's quite misleading to the public, because what they're actually going to have to pay is almost twice that amount in there. And while this is not the subject of it, but I think there's something to consider, that in the truth we've been trying to get to of people making an informed decision to honestly understand what is involved. What are your thoughts about requiring the amount to be repaid to be part of the information that's placed on the ballot so that they can make a truly informed decision?
I think that's very important information to include on any forthcoming propositions. Voters ought to know the full cost of whatever is being proposed so that they can accurately determine which direction to go. One of the reasons that I did this report and another looking at the November 2023 cycle was that I was actually a bit frustrated with what was being reported in the local media, because oftentimes, in fact, in almost every situation, the media would only report on the proposition amount that was being offered by the government, and that only reflects the principal amount, right? It discounted the interest item. And so what I wanted to know is, you know, of all of the various items being put before the public, what is the full weight of these things? And so it took a little time to work through 325 voter information documents, but we were able to collect that information and provide it for public consumption. And I think what it shows is very troubling.
Okay.
Thank you, Senator Hall. Members, any other questions for Mr. Quintero? Senator Parker, you're recognized.
Thank you, Mr. Chairman.
Thank you, Senator Birdwell.
James, I simply just want to say I think the work is exceptional. Thank you for such precision. It's rare that we see this level of detail, in all these different elections with not just the total dollars and so forth of the indebtedness, but the specifics of the vote and so forth. It really is a great resource for us to study this issue thoughtfully and thoroughly. So kudos to you and the Institute for the great work at TPPF.
Thank you, sir.
Thank you.
Thanks, Senator Parker. Members, any other questions for our witness? Thanks for being here. Thanks for your
Thank you,
testimony. We'll open public testimony on Senate Bill 533. Public testimony is now open. The chair calls Julie Wheeler. Julie is the only witness we have registered at this time to testify on, for, or against. If anyone wishes to testify on, for, or against Senate Bill 533, please register outside or make your way down to the table. Welcome.
Good afternoon.
Get situated there and introduce
no.
yourself. Give us your testimony.
It's higher than I thought it was. Good afternoon, Chairman Hughes, members of the committee. I'm Julie Wheeler, the Intergovernmental Relations Officer for Travis County, and I'm here on behalf of the Travis County Commissioners Court on Senate Bill 533. As you know, counties have to live by the plain text of bills, of statute. It really serves as our instruction guide, and that's why the less ambiguity, the better for us. We are hopeful that we could make just a minor refinement to the language that Senator Sparks has presented. And so it would be a few words added on lines 8 and 9, and we're hoping that it will clarify that it's those tax rate increases that are required under Tax Code 2607. So the language would just say, an election for the issuance of bonds or other debt or a tax rate increase election required by Tax Code 2607 shall be held on the November uniform election date. So again, we had a room full of attorneys quibble over the language, and they just wanted to see a little bit of refinement within that. I'm happy to answer any questions, but that's really the crux of our ask. We thank Senator Sparks for this bill. Thank you.
And thank you. Members, any questions for Ms. Wheeler? And thank you for that. Obviously, your involvement in this process helps us get it right and creates questions on the back end. I'm sure you have. If you haven't, will you all be in touch with Senator Sparks' office and work and share that with him as well?
Yes, and we've already spoken to both Senator Sparks and his staff, and we appreciate their willingness to work with us on this.
And thank you. Thanks for being here. Thanks very
so
much.
much. Thanks.
Anyone else wishing to testify on, for, or against Senate Bill 533? Seeing none, public testimony is closed. Bills left pending at this time. The chair now lays out Senate Bill 318. Senate Bill 318. And recognizes its author, Senator Creighton, to explain the measure. Senator Creighton, welcome.
Thank you, Mr. Chairman, members. It's a good day to be in State Affairs.
It is.
Very distinguished committee here. Mr. Chairman, members, Senate Bill 318 creates an election integrity division in the Office of the Attorney General. Right now, there are election integrity attorneys assigned to such cases in the AG's office, but it's under the criminal division that's established because it is a high priority for General Paxton. But in the future, not necessarily knowing if future AGs will make sure that this priority set remains of the highest in protecting the public against those types of incidences that have happened, like in my home county, where we have not only had election fraud, we have had election results overturned, and those convicted of election fraud served time in recent years. Senate Bill 318 creates an election integrity division within the Office of the AG to safeguard the integrity of elections and ensure public confidence in the electoral process and investigate election fraud offenses. There's no fiscal note to the bill, members, because it is creating a division in the AG's office so that it will most certainly remain a priority that needs to be addressed always and into the future. The bill allows the Election Integrity Division to issue administrative subpoenas to compel political subdivisions, local political entities, to provide information, documents, and witness testimony to assist in those investigations. Regardless, again, of who is serving, as we know, General Paxton's been very successful in this effort and working within this space. We need to know that it's a priority. I've worked for the Texas Attorney General in the past. I served as a criminal appellate brief writer in the Criminal Appellate Division of the Oklahoma Attorney General's office for a couple of years, and the way that our Texas Attorney General's office is structured, I believe, and I hope that you would believe and share in those thoughts, that it would be very important for that division to be on its own and exist to safeguard the public. And with that, I'm willing to answer any questions, and thank you, Mr. Chairman, for your consideration.
And Chairman, thank you for being here. Thanks for this bill. Members, any questions for our colleague on Senate Bill 318? Very well, we'll hear from the witnesses. Thanks for bringing the bill.
Thank you. Thank you, Mr. Chairman. Thank you, members.
We'll open up invited testimony, and the chair calls Jeff Barr, Brent Dupree. Good afternoon. Welcome back. Saw you earlier. Do y'all have a preference as to who goes first?
Chairman and committee members, my name is Brent Dupree. I'm the Director of Law Enforcement for the Office of Attorney General. I'm really here to answer any questions you might have as to the investigations that are done within the Criminal Investigations Division related to election integrity.
Thank you very much. We probably will have questions. And go ahead and introduce yourself again.
Thank you, Chairman, Madam Vice Chair, and members again. Jeff Barr, I'm the Division Chief of the Election Integrity Division of the Office of the Texas Attorney General, which is, again, focused on prosecutions. Here to answer any questions as a resource witness.
And thank you both for being here. As, pardon me, as the author mentioned, very thankful to have this division active and supported and funded in the Attorney General's office. As I understand the author's intent, because this is so important, the desire is to make sure that the office exists statutorily regardless of who's in the office of Attorney General. And so from the standpoint of how the office functions and the work you're doing now, would passage of this bill interfere with anything you're doing or hamper your efforts or change the way you're doing things today?
Respectfully to Senator Creighton, it could. It very well could. I want to outline three three issues that I think come up with this potential bill. And with that, I'm going to give you a little bit of background of the history of General Paxton's Election Integrity Division. And I think it gets confused maybe in the media. I think maybe it gets confused at the State House here, and sometimes it might even get a little confusing at our own agency. But the Election Integrity Division, as it's named now, is a spin-off, is a division, a very small division that is comprised of criminal prosecutors that was spun out of our Criminal Prosecutions Division, I think sometime in 2020. It was before my time as the chief. And it was to support General Paxton's initiative. It was one of two major initiatives, human trafficking and HTOC, human trafficking, I get the rest of it messed up, and election integrity. So it was major priorities of General Paxton. So he created separate divisions, prosecution divisions, for those two. And so currently we have a criminal prosecutions division, we have a human trafficking division, and we have an election integrity division. I liken election cases, at least post-Stevens, to being a seasonal lifeguard, if you will. Unlike traditional crimes, human trafficking, homicides, where I spent much of my career at the AG's office prosecuting, election integrity crimes generally develop in and around election seasons. And so those are when the complaints come in, those are when the investigations start. And so there are times, at least since during my brief tenure of over about 2.5 years in this division, where we don't have cases to prosecute. And so to be good stewards of the taxpayers' resources, we have taken assignments from the criminal prosecutions division of traditional crimes in support. Now, that being said, election integrity prosecution is our priority. And so we step up into that role when we need to step up. But if we're having a slow season, then we're able and we're trained and we're experienced to take on a variety of traditional election crimes. My concern with the bill is that I question whether it would be specifically funded for only election prosecution causes or matters like the HTOC unit currently is. So currently in our HTOC unit, the human trafficking unit, they cannot take on other non-HTOC-like or human trafficking-like crimes. They can't prosecute a homicide or a burglary. And so I think they have to, from my understanding, they have to answer to the legislature on those crimes. Again, those aren't seasonal crimes. Human trafficking happens all the time, all over the state. And so they get complaints all the time. Elections are not like that. So that's issue number one. Issue number two, as we've been talking about today, is the Stevens decision. Certainly has hamstrung our ability to concurrently prosecute. And then third, one of the other reasons we're not seeing a lot of election prosecutions is we're pro tem, we're DA pro tem, or we're assisting DAs on a handful of cases currently right now, and some of them are vote harvesting cases. Well, currently there's a federal lawsuit that has preempted or stopped and joined our ability to prosecute vote harvesting. So that's shut us down. And so it's these types of elements that gives me a little bit of pause as to forming a formal division for election integrity. I think it's a great idea. I just want to make sure y'all are aware of those issues. I think Director Dupre would probably tell you something different as to his side of the house, which is the election investigations. They stay busy because they get requests from DAs, they get complaints from the SOS, they at times self-initiate investigations, I think he'll tell you. And so they've got a lot of investigations going, but then they're sending those to DA's offices. We might get a call on it, we might not on the prosecution side of the house.
And thanks for that. We're going to have some more questions, I'm sure. Director Dupre, would you want to talk about that as well?
Yeah, thank you very much. As Mr. Barr stated, whenever the Election Integrity Division was formed, a companion division within the Criminal Investigation Division was formed, and over which I oversee, which is the Election Integrity Unit. So working along with the Election Integrity Division within the Criminal Prosecutions Division is the Election Integrity Unit of Investigators, in which we investigate the criminal cases around election crimes. Those cases come to us in many different forms, either from local officials, from local police departments, other police agencies, and the Secretary of State's office. I do not see this bill impacting the work that we do. We would continue to do that work as those complaints or investigations come to us. And then since the Stevens ruling, we have been referring those cases to county and district attorney offices for prosecution. So we would continue that work under this bill as well.
Thank you. Senators, any questions? I asked those witnesses questions without yielding to the committee first. Senator Parker, go ahead.
Thank you, Mr. Chairman. I think my mic is out, the light here. I don't know what's going on there. Listen, I just wanted to clarify for a moment, Mr. Barr. Thank you for your feedback. Obviously,
Senator, will you get a little closer to that microphone?
Yes, can you all hear me?
I'm not sure it's working.
I think that's the problem.
Oh, it is now. It is now.
No. I think, Mr. Barr, just to be clear, I think the author's intent here is just to establish this, that it is always a priority permanently for the AG's office until the Lord calls us all home. and so, as a result of that, I mean, that being the intent of the author, I think your issue is not any concern with intent, but rather just the application, given the fact that there's an ebb and flow. You said a seasonality, so to speak, to the work that you would do. And so I guess my question is, one, just making certain you understand the intent, that it would be permanent beyond the current Attorney General, who's done such a great job with this topic of election integrity, and making certain that it's permanent. But the issue, I guess, or the question is, isn't there a way to work internally to figure out how workload would be shifted and how various personnel could be shifted from one permanent division to another based on the seasonality? I mean, certainly there's got to be a way to work that out to where it doesn't become problematic for the general. Is that right?
I would hope so. That was what I'm trying to convey, I guess, is that I hope that there would be some flexibility. I think there would need to be some flexibility for us to be able to do that.
And obviously that's something that you all can work through and talk about amongst the office, and obviously with the author as well, with Chairman Creighton to talk about what that looks like in terms of the bandwidth and how you would share effectively employees between different sectors, if you will, of the AG's office. I mean, you all should be able to work that out, I would think.
We should be able to, yes.
Yeah, very good. Thank you.
And thank you, Senator Parker. Members, any other questions for our resource witnesses from the Office of the Attorney General? And thank you both for being here. Thanks for your testimony.
Thank you. Thank you.
Public testimony is now open on Senate Bill 318, and the chair calls Dr. Laura Presley, Veronica Warms, Emily French, and Ken Moore. Looking for Dr. Laura Presley, Veronica Warms, Emily French, and Ken Moore. Looks like we have everyone. And as these witnesses are preparing to testify, I will announce anyone wishing to testify on, for, or against Senate Bill 318. Please step out in the hall and register electronically or come to the table and let us know. And we will begin over here. On my left, your right. Fresh, welcome back. Remember when you're on the end of the table to get close and introduce yourself and go ahead.
Yes, sir. Good afternoon. I'm here to testify in opposition to SB 318. I have many issues with this bill, but my focus today will be on results. I respectfully disagree with the bill author that the...
Hold tight. We'll start your time over, but I forgot to tell you to go ahead and tell us your name and make sure we get it on there. Go ahead.
Hello, I'm Emily E.B. French. I'm representing Common Cause Texas, and spoiler, I am here to testify in opposition to SB 318. I have many issues with this bill, but I'll focus on results. I respectfully disagree with the author that the unit is successful. From the numbers reported, it seems wildly inefficient to me. From October 2020 to September 2021, the Attorney General's team of lawyers worked on more than 20,000 hours on election cases, and they closed 3. They also closed only 3 per year in 2016, 2017, and 2019. From 2005 to 2023, the Attorney General's office successfully prosecuted 155 individuals for election fraud. During that same time period, Texans cast more than 107 million ballots. The Attorney General's office sunk its manpower, time, and money into 0.00014% of the vote. If they're seasonal lifeguards, the water is clear and nobody is drowning. This minuscule rate might be more bearable at a lower price tag, but despite the lack of fiscal note, this bill will cost Texans money. In the 2022 to 23 fiscal year, the unit prosecuted 4 cases and spent nearly $2.3 million. From September 2023 to August 2024, they closed just 2 cases and spent about $1 million. The election integrity unit seems to be a terrible steward of taxpayer funds to me. The Attorney General is supposed to serve and protect the rights of all citizens of Texans, but instead, this election integrity unit uses a massive amount of resources and achieves a minimal impact. This division represents a serious deficit of government efficiency. We do not wish to see this division enshrined in law, and so we oppose this bill. Thank you.
And thanks for your testimony. Ms. Warnes, welcome back. Introduce yourself and give us your testimony.
Right. Again, spoiler, my name is Veronica Worms, representing the Texas Civil Rights Project against SB 318. SB 318 creates an election integrity division in the Attorney General's office, permanently and officially solidifying the existence of an entire team for the purpose of pursuing often baseless claims of election fraud. We oppose this state overreach for several reasons. The legislature mandating that the AG's office create an entire division for pursuing these cases is deeply concerning given AG Paxton's track record. According to an ACLU report, the AG's office has disproportionately pursued voters of color in its election fraud investigations. To put that into numbers, of the AG's office's election fraud cases, 72% were against Black and Latino Texans. On top of that, 45% were brought against Black and Latino women. However, we also have concerns about the legislature requiring this office to exist regardless of what AG takes office. The Attorney General is an elected office, and each candidate for that office should be allowed to set their own priorities without the legislature mandating the AG's agenda. Requiring an election integrity division perpetuates the myth that there is widespread voter fraud in this state, while simultaneously making it scarier for Texans to vote. Knowing there's an entire division of the state attorney general's office that could potentially be after you for any mistakes made in the elections process, after all, the election code contains more than 100 criminal offenses, will deter voters from participating in our democracy. Making it scarier for Texans to cast a ballot is not the way to further election security. I urge the committee to focus on positive policy proposals, such as expanding voter education and access to the polls, instead of tasking the AG's office with an ineffective and regressive mission. Thank you.
Thanks for your testimony. Dr. Presley, welcome back. Introduce yourself and go ahead.
Yes, I'm Dr. Laura Presley with True Texas Elections, and I fully support, strongly support Senator Creighton's bill. I'd like to raise this up to a 30,000-foot view for just a moment. Candidates and voters do not trust elections in Texas. If they did, we would not have the huge effort on hand-counted paper ballots. That is because voters and candidates don't trust our elections in Texas. It's an extreme solution, which I have never really supported because I'm a technologist. But you can't argue with the fact that the trust in our elections is at the lowest possible. Even at the federal level, we have a Texas congressman who is calling for removal of voting machines. That's a fact. Because candidates and voters have lost confidence in our elections. It's not a pretty fact, but it's true. We have to consider why this is. The Attorney General's office has not focused enough, regardless, whether it's resources or whatever, dedicated assignees to attorneys and investigators. If that's the root cause, this bill should address it. I believe that the AG's office needs to be stronger with looking at not just voter fraud, but looking at electronic fraud. If you look at the number of ballots that can be impacted by a machine algorithm or some type of hack or whatever, which we know is possible, those number of votes are massive compared to individual voter fraud, illegals voting, or even ballot by mail, which is 5% of the vote. I would propose a some stronger language that would say there's, within the elections division, you would have a physical ballot investigation or division, but also a technology electronic fraud division. I have met personally with the Attorney General's office, and they have no experts on electronic fraud. They have no experts. They need the experts. In even number years, 8 months out of the year, elections are happening. So this is not a seasonal thing. I'm really struggling with that perception. And there have been cases that have gone to trial, and I was an expert witness in one in Dallas County. Fraud, electronic fraud, if I could finish, Senator Hughes, electronic fraud evidence was presented to the court, and the defendants asked for access to the voting machine software. The district court said no, the appeals court said no, the Texas Supreme Court said no, you can't get to it. Maybe the Attorney General could get to it, because to prove electronic fraud, you have to have access to these machines. And until there's access, people in this state are not going to trust the electronic voting. I'm here for questions if you would like.
Thanks for your testimony. Mr. Moore, welcome back. Make sure and get close and introduce yourself. Give us your testimony.
Okay. My name is Ken Moore. I'm representing myself, and I'm testifying in favor of this bill. A few sessions ago, one of the recurring arguments against SB 1, which is a landmark bill that helped us a lot in election integrity, was that it was a solution looking for a problem. It was often called the big lie, the idea that we actually had voter fraud. And they would point to how few cases are actually being prosecuted, how few are being investigated. Well, there is no big lie. You have heard a parade of testimony, people coming through here, talking about the issues we've had in Harris County and other counties. And if you need more, you'll hear more when we get to SB 507, where I have quite a few things we want to talk about. But there are real problems with local election officials and candidates not following the law. And ironically, SB 1 actually helped shed some light on many of these, with their reconciliation requirements. But the reason I would suggest that we don't have these investigations, the prosecutions, is simply lack of personnel and resources devoted to it. This bill, SB 318, addresses this problem, and I would ask you to please move it forward.
Thank you for your testimony. Members, any questions for any of our witnesses on Senate Bill 318? I do have one, and statistics are helpful, the numbers are. I want to see about a little context. And Ms. Worms, I was going to ask you, I want to make sure I wrote this down right. You were discussing the demographics of the folks who've been investigated, and I think you said 72% of those investigated by the Attorney General's office in a given time were of Black or Latino. Is that close?
That's correct.
Okay, thank you. And you may not know this, but do you know in how many of those cases where Black or Latino Texas were investigated, do you know how many of those cases where the complainant was also Black or Latino? Because I know that was true in many of those cases. Do you have those numbers?
I do not have those numbers in front of me, but this was prosecutions and investigations that were instigated before the Stevens decision. So this is when OAG felt that they had the authority to pursue these cases.
And I don't want to put words in your mouth, but I want to be clear. You're not suggesting that if a Black or Latino Texan raises a complaint that involves another Black or Latino Texan, that we should not pursue that just because of the race of the alleged violators or the folks bringing the charge, are you?
I'm not suggesting that. What I am suggesting is that there has been a disparate impact against voters of color, seemingly in the data regarding the investigations that OAG instigated at that time.
But would those numbers mean more if we knew the same demographic data for the complainants in those cases?
I think that it's still worth looking at what the disparate impact and the data tells us regarding what cases the OAG decides to pursue. I don't have the information on who the complainants were in those cases.
But if we had that information, that would be helpful context, wouldn't it?
I mean, context is always helpful. I would never disagree with that.
Thank you very much. Members, any questions for any of our witnesses? Thank you all for being here. Thanks for your testimony. And those are the only witnesses we have registered on for or against Senate Bill 318. Anyone else wishing to testify on for or against Senate Bill 318? Seeing none, public testimony is closed. Bill's left pending at this time. The chair lays out Senate Bill 108 and recognizes its author, Senator Hall, to explain the measure. Senator.
Thank you, Mr. Chairman and members. This is a very simple bill to try to straighten out a situation we find at our election polling places due to a gap in the law not really addressing it. And it's all of the state, not just one county in there. The county bills are coming up after me. And elections are driven by politics, but the election process itself should not be political. It should be nonpartisan. Current state law is silent on the issue of how the presiding judge appoints and assigns workers in the polling locations. By making statutory provisions for these actions, it will standardize the process and ensure that the politics are left out of it. Chapter 32 of the Election Code provides for the appointment of a presiding election judge and an alternate presiding judge for each election precinct. In past elections, some counties allowed for the presiding judge of a polling location to be the sole appointer of election clerks, which could create an unbalanced system where irregularities could occur. Every part of an election should be conducted fairly so voters have confidence in the integrity of the results. SB 108 would ensure the sharing of political power by creating a procedure where both the judge and the alternate judge may appoint clerks. The bill specifies that the alternate presiding judge shall serve as a presiding judge if the presiding judge is not present at the polling location or otherwise cannot serve. It would allow also an alternate presiding judge to freely occupy or observe the area where the voters are being accepted for voting, and would allow an alternate presiding judge as well as the presiding judge to appoint election clerks. The bill would also specify that a list must be submitted to the presiding judge and alternate presiding judge, and that each shall appoint at least one clerk from the list. The bill would also add subsections emphasizing that the presiding judge and alternate judge shall each appoint the same number of clerks to the extent possible, giving the total number of clerks to be appointed. With that, Madam Chair, I'll be glad to take any questions.
A lot of teleportation going on today. Yeah. So thank you, Senator Hall. Members, any questions? If not, Chair opens public testimony and calls Lucy Traynor and Dr. Laura Presley. Lucy Traynor and Dr. Laura Presley. Appreciate y'all being here today. Dr. Presley, you want to go first? Introduce yourself and give us your testimony.
Yes, thank you, Senator Paxton. Senator Hall, this is great. Thank you for closing this, some loopholes that we have in the election code. I just would like you to consider circling back with Chapter 127 of the Central Counting Station to make sure that the alternate judges are not subjected to the presiding judge at Central Count, because I have trained 1,000 watchers around the state of Texas over the last 8 years, and with debriefs of those watchers, we've had situations where I experienced it myself, and when I was a watcher, that the alternate judge of the Republican Party in the county I was watching was Travis County. the presiding judge of the central counting station relegated the alternate judge to a clerk position, and I know your bill repeals that at the polls, but I'm concerned a little more at central count. For this example that I experienced, the presiding judge at central count relegated the alternate Republican judge to a clerk, made him go out to the dock to watch materials being delivered, and he wouldn't do it, and they ejected him out. So I'd just like you to kind of close that loop with central count and maybe the ballot board also, because it's not just at the polls where this is occurring, it's at those other two locations. And I just want to plant that seed.
Thank you. Senator Hall, any
Why don't
questions?
you get with us after this,
Yep,
after this, and we'll go over the bill and see if there's something we might need to do to tighten it up, because I
Okay.
certainly want to make sure that we keep a balance
That's right.
between the judge and the alternate judge across the board.
Yeah, bless you.
So,
Thank you.
All right.
Thank you, Senator Hall. Members, any other questions for Dr. Presley? All right. Lucy, if you'll introduce yourself and give us your testimony. Thanks for being here.
Lucy Trainer, SREC ST25, for this bill, of course. And I've got close friends with Travis County GOP, and I want to just share some of the statistics that they took in for this last general election. I think it really speaks to the need for this bill. With 70 locations, they're at 70 locations in Travis County, and I think there was a total, this is on election day, of the 70 locations of 176, we had, it was probably 70 locations with no Republican judges or alternate judges at 70 locations here in Travis County in the general, just this latest general election. Other things that the leadership staff had recorded was that 18% of those of those that were placed were not even on the list that was provided. So the county chairs, they submit these lists to the commissioner's court, right? And the county chair asks for the list that's placed, say about a month before, a little before then, with the elections. And Travis County didn't give the GOP chair that list. They gave it to them the beginning of early voting, which was long after they had requested it. So as to the Republican clerks hired, 57% were not even on the list. And then they looked up the names. The people within the GOP looked up the names, and many of them were very partisan Democrats. So I think this is a great bill. It really speaks to equity that's needed with our polling locations. What happens with in these situations where you have an elections administrator with as an unelected bureaucrat, and they are appointing all of these clerks, alternate judges that don't really fully represent what the precinct looks like or what the county looks like as a whole. So we've got to have, and I would say, Senator Hall, I think having some kind of penalty with the elections administrator office when they don't relinquish that placed list to the county chair, that would be a great thing to do. I don't know what that would look like from a practical standpoint, but it would be helpful in terms of accountability, because right now they ignored Travis County in 2022 on that list, and they ignored them in 2024.
Thank you. Thank you for your testimony. Members, any questions? Senator Hall?
No, I'm good.
All right, thank you both. We appreciate you being here. You're free to go. All right, we do not show any other registered public testimony. Is there anyone else in the chamber wishing to testify on, for, or against Senate Bill 108 by Senator Hall? Hearing none, public testimony is now closed and the bill will be left pending. All right. The chair lays out Senate Bill 507 by Senator Betancourt and recognizes the bill's author, Senator Betancourt, to explain the bill.
Thank you, Madam Chair. This is Senate Bill 507, is a refile from last session. We ran into a spectacular failure in Harris County, Senator Hall. I'm sure you're shocked that we had a problem of getting Senator Hinojosa millions of ballots out of the warehouse to voters to vote on. And this resulted, let's see, what year is this now? This resulted in a record number of election contests, of which one was actually sustained. And it was based upon the incredible incompetence of an election administrator. Gee, can't imagine we've had these things before. And importantly, what we found out that failure to distribute election supplies was just a Class C misdemeanor. And this bill basically increases that to a Class A misdemeanor, and if there's an obstruction of distribution of election supplies, it increases it to a state jail felony. It also makes 2 additional Class A misdemeanors. The authority responsible for procuring the election supplies from an election commits an offense if the authority intentionally fails to provide an election precinct with the required number of ballots. The authority responsible for procuring election supplies for an election commits an offense if the authority intentionally fails to promptly supplement the distribution of ballots upon request by a polling place. And Madam Chair, you might be happy to know that despite the fact that the Election Administration Office was immediately notified of the lack of ballot paper by multiple sources, including direct visits to their warehouse, even though that was ignored. In fact, one person that went over was threatened with an offense of trespassing if they didn't leave, okay? Trying to get that information through. That finally the decision was made by the then election administrator, Cliff Tatum, to release more ballots, and they got on the road at 3 o'clock. Well, they didn't finish delivering supplies till 9, which was even too late past when they received a court order until it was overturned by the Supreme Court to keep the polls open. That particular person testified in committee that she was given 4 precincts to go to in the 4 geographic points of the county: northwest, northeast, southwest, and southeast. And she said to the supervisor that this would be impossible for me to get there by 7 o'clock, and they said they knew, and she should do her job. So we're going to do our job by increasing the penalties on this in this area, and I won't belabor the fact that we had obviously polling places that didn't have ballots, and the fact that the one election contest was sustained, which is the only overturn of an election in the United States that I'm aware of in a major urban county in 2022. With that, be happy to answer any questions.
Thank you, Senator Betancourt. Members, any questions for Senator Betancourt? Senator Betancourt, I have a question just for everyone listening. So the original penalty was a Class C misdemeanor?
Yes.
And this will raise it to a Class A misdemeanor. What does that mean?
Well, that means a substantial difference in the possibility of time served, jail time, and it makes it very obvious that this type of behavior should not ever occur again, because a Class A misdemeanor is a substantial offense. Also, too, from the standpoint of people actually investigating these crimes, it's very difficult to get, as people know, especially after the Stevens case, getting anyone interested in voter integrity cases. But when the only result is a Class C misdemeanor, which is effectively a traffic ticket, it's not only ignored, but just flat bypassed.
Thank you, Senator. Appreciate you bringing this bill. All right. The chair opens public testimony and calls Dr. Laura Presley, Veronica Warms, and Ken Moore. Dr. Laura Presley, Veronica Warms, and Ken Moore.
And Madam Chair, if I could?
Yes, Senator
I do
Betancourt.
appreciate everybody that's clocked into work today to come testify, because Ed Johnson is sick, and therefore he wanted to notify the committee that he could not attend today. So
Thank
we
you.
would grant him a pass. Madam
Yes,
Chair.
yes. Thank you,
We're
Senator
channeling-
Betancourt.
we're
All right. How about if we start with you, Mr. Moore? If you would go first, introduce yourself and give us your testimony.
Okay. My name is Ken Moore. I am for this bill. I'm representing myself. Now, I remember this incident that the Senator Betancourt is talking about very, very well. I mean, it splashed across the news. And it was a topic of conversation anywhere you had Republican clubs, what have you. I went to Harris County Commissioner's Court shortly after this thing. And they had a lot of people testifying, many of whom were election judges. And it was one horror story after another, the things they went through. Some started calling the county as they saw their supply paper running low. Some called first thing in the morning when they knew they would not have enough paper for the day. Some were promised paper would be delivered shortly, never arrived or arrived late. One judge reported the county told them, nonsense, you have plenty of paper, don't call us again. One judge reported voters were getting agitated. One voter began threatening the election workers, and they had to call the police. Many could not get anyone to answer the phone. Most reported they saw voters give up and leave the polling place. They may have gone to the polling place, we don't really know. Those who did get through the county reported long waits for ballot paper. When the county gives election judges a phone number to call when things go wrong, somebody needs to answer the phone. That's just common sense. And Senator Betancourt, in his bill analysis, he pointed out that there were like 120 polling places that were short on paper. Now, another nice little interesting fact about Harris County that he didn't include was the parts that are not underwater is 1,700 square miles. And so you get that many polling places scattered over that broad a distance. You need a lot of people delivering supplies. Anyway, I support this bill. Please pass it on.
Thank you. Thank you for your testimony. Dr. Presley, introduce yourself and give us your testimony.
Thank you, Madam Chair. Senator Betancourt, I love this bill. I would just like you to consider potentially one very minor amendment, but it would have a huge impact. That in the Chapter 51, which is where you're proposing this, that the timing of the delivery should be consistent with 51.004, which says supplies to the polling location must be delivered an hour before the polls open. So the question is, when do these people have to deliver these ballots? You've left that open. That should be really closed and tightened up. In Williamson County, it's really shocking. We have the voting system ballots, and they'll dole them out onesie, twosie packets instead of delivering it all at once at the poll so that the judges have everything they need. And it's very confusing when you're trying to add up how many ballots did I receive as a judge, you know, in your final ballot register to let you know how many ballots. Well, we got 100 this day, we got a couple hundred that day. It's a hairball. I've been there at closing trying to help them get their numbers straight. Because if the numbers are off, they have to go scan the ballots at central count. So really, we need to tighten this on a timing, and everything needs to be delivered that morning so everybody's good to go. I want you to consider that.
Thank you.
Okay, bless you. Thank you.
Thank you. All right. You want to give us your name and give us your testimony? Thank you.
Of course. My name is Veronica Worms, representing the Texas Civil Rights Project against SB 507. SB 507 adds to and increases the severity of a number of criminal penalties for election workers and officials. This measure will not make our elections more secure or run more efficiently. Texas counties are already struggling to adequately staff our elections with the resources the state provides. According to a report from the Bipartisan Policy Center, our election official turnover rate nationwide has grown from 28% in 2004 to 39% in 2022. In the 2024 election cycle, the turnover rate in Texas was about 40%. This turnover rate is causing a massive loss of institutional knowledge regarding election administration across our state, making the voting process more difficult for both voters and election officials. One of the primary reasons for this loss is because the legislature relentlessly increased and criminalized the duties and responsibilities that election officials and workers are required to accomplish with the inadequate resources provided to them. Instead of adding yet more criminal penalties into this equation, this body should adequately fund elections so that counties have the resources and staffing necessary to quickly respond to any immediate changes or needs. We ask the committee not to report SB 507 favorably. Thank you.
Thank you. Thank you for your testimony. Members, any questions for our witnesses? All right. Thank you for being here. Appreciate it. And you're dismissed.
If I could, Madam Chair, just wanted to.
Senator Betancourt, you're recognized.
Just on a quick close. The end result of the investigation in Harris County was on a tangential matter, but directly related, was that one election official was indicted. They were working two jobs simultaneously, and the job they weren't paying attention to was, of course, the county job. That it was the person that was responsible for allocating the paper in the county at the time, and so. When you go back and look at that, it was, incompetent as well as corrupt. And fortunately, other bills that this committee passed, Senate Bill 1750 and Senate Bill 1933 also passed the House. And we now have elected officials that have been doing a far more competent job in Harris County.
Thank you.
With that, I would thank the time for the committee and the witnesses.
Thank you, Senator Betancourt. Is there anyone else wishing to testify on, for, or against Senate Bill 507? Hearing none, public testimony is now closed, and the bill will be left pending. There's another tap for that. 1433. Oh, I see it. All right, the chair lays out Senate Bill 511 and recognizes its author, Senator Betancourt, to explain the bill.
Thank you, Madam Chair and members. During the 2024 elections, Bexar and Travis County spent taxpayer funds to contract with a company to send out unsolicited voter registration cards. Senate Bill 511 bans an officer or employee of the state or political subdivision of the state from distributing voter registration cards to a person who did not request it, with a few exceptions. The bill would still allow for volunteer deputy voter registrars and high school deputy voter registrars to continue to provide voter registration cards, as well as a political party or candidate for any office to continue to send them out. What Senate Bill 511 would do is prohibit an officer or an employee of the state or political subdivision from using public funds to distribute voter registration cards without a request from the public. The important thing is we've done the same type of restriction for absentee ballots by mail applications. If someone requests it, the government can send it to them. But quite frankly, in lieu of that, we've got volunteer deputy registrars, high school deputy registrars, political parties, candidates everywhere that do this, and they can do that work unsolicited, but government shouldn't be putting their thumb on the scale by doing this without a solicitation from the voter, just like we do with absentee ballot locations. I do have a committee substitute.
Senator Hall sends up the committee substitute for Senate Bill 511.
Oh, excuse me. We will have a committee substitute.
He just changed his mind.
Yeah, I just changed my mind.
Senator Hall changed his mind about
it. Anyway, the committee substitute, when it's ready, will address federal requirements for distribution of voter registration cards brought to us by HHSC last night, and about the creating a Class A misdemeanor code in that area. And so we do have Kyle Sinclair, who may be testifying, maybe for the first time, I'm not sure. Okay, it looks like he is. With that, be happy to answer any questions.
All right, thank you, Senator Betancourt. Senator Hall, you have any questions about the committee substitute or anything else?
It's
No, you don't?
Not Harris County this time.
All right. Thank you. Thank you. Okay, the chair opens public testimony on Senate Bill 511 and calls Lucy Traynor, Emily French, Ken Moore, Mary Ibarra, do we have 5? Oh, and Kyle Sinclair. So we've got 5 seats there. Take whichever seat you like. All right. And if we can start on this side, on my left, your right, state your name and who you represent and your position on the bill, and we'd love to hear your testimony. Thank you.
1 second, sorry.
And you may need to lean into the mic a little bit.
Okay, thanks. Good afternoon, Senators. My name is Mary Ibarra, and I'm a policy and advocacy strategist representing the ACLU of Texas, and I'm here to testify against SB 511 and ask that you oppose this bill. There are many reasons why we oppose this bill. I'll start with local government control. Counties should be allowed to maintain discretion over their budgets and how it is spent on elections. Local government and local elected officials, such as those who pass county budgets and oversee elections, have a unique and closer understanding of their constituents' needs. Texans want to say in the decisions that shape our lives, from the way we run our communities to the local officials we elect to represent us. Second, Texas has one of the lowest voter turnout and participation rates in the country. This past November, only 61% of registered voters cast ballots in the general election, a nearly 6 percentage point drop in turnout compared to 4 years ago. Unilaterally limiting outreach efforts to educate voters on their eligibility to participate in the electoral process and register to vote will further truncate voter participation issues that the state already has. There are also many what I assume are unintended consequences of this bill. This won't just affect county elections offices. The language in this bill is ambiguous enough that voter registration forms will no longer be able to be distributed at post offices, libraries, local and state government offices, like Health and Human Services, DPS, Texas Workforce Commission, or offices providing disability services. Many counties also include voter registration forms when in marriage license and name change packets. That will be limited in this bill. Other states, even red ones, allow for same-day voter registration, online voter registration, or automatic voter registration. Closing the gap of eligible and registered voters is an example of good governance, and this bill would further hinder those efforts to achieve higher participation in our democracy. Thank you.
Thank you for your testimony. All right, if you would introduce yourself and then give us your testimony. Thanks for being here.
Thank you, Vice Chair Paxton and members of the committee. My name is Emily E.B. French. I am from Common Cause, Texas, and I'm here to oppose the bill in its current form. This bill would prohibit an officer or employee of the state from distributing an unrequested voter registration form. I understand what it is aiming at, but I believe it's really broad. It would become illegal for a county office to have voter registration forms placed on a counter or at a walk-up window, as I read it now. A would-be registrant would have to say a specific trigger phrase in order to get a voter registration form at a county office. My reading is that I couldn't get a form out of a county official by saying, "Is there anything else I need to do at this appointment?" Or, "I sure wish I could get a voter registration form," or, "Do you know where voter registration forms are?" Because none of those are technically a request for a voter registration form. I don't want us hiding voter registration behind a set of magic words. I'm excited to hear that there's a committee substitute. A large part of my original testimony focuses on there's no carve-out for voter registration agencies designated under Section 20.001 of the Election Code, which is HHSC, which it sounds like the committee sub addresses. But that also includes, as my colleague Mary said, the Texas Workforce Commission, DPS, Department of Aging and Disability Services, public libraries, marriage license offices. If this bill becomes law without a carve-out for all of 20.001, those agencies will be required to offer voter registration while their officers are prohibited from offering voter registration. Ironically, this bill would specifically allow those agencies to invite a partisan political candidate to come into their office to offer voter registration for them. Distributing voter registration forms is one of the core functions of a county voter registrar. This bill would curtail that function drastically and needlessly. For those reasons, we oppose this bill. Thank you.
Thank you for your testimony. If you'd introduce yourself and give us your testimony. Thank
Absolutely. My name is Kyle Sinclair. I'm a native Texan, Army veteran, and I have been in San Antonio since 2009 with my family. I'm for this bill, and what I want to do today is share the experience we had in Bexar County. And Bexar County uncovered a lot of stuff across the state of Texas. I think many in this chamber did not understand what was going on. That we worked with the Attorney General's office, we worked with the Governor's office, U.S. senators, U.S. reps, and many state reps, as well as many senators. And what we uncovered in Bexar County in particular, there's an organization called Civic Government Solution that got a contract for $400,000 in Bexar County to register 220,000 members in Bexar County to do what they thought was going to, which is increase the voter turnout. What we uncovered is that organization, Civic Government Solution, had a founder which also had a partisan organization called Civitech. And Civitech, according to their website, was extreme partisan, and I can outline many things. But we uncovered that they were communication out of 254 counties in the state of Texas, with 40 of them had 4 under contract. And if you use those simple maths of what Bexar County gave them of $400,000, you're talking $16 million for one of the biggest partisan data that voter registration across the state. We also found that organization was uncovered in 4 different states doing this exact very thing. And so the interesting thing that we found is that Civic Government Solution was taking that registered data information and pushing it over to a company called Civitech. And Civitech's main goals, at least according to the founder, I'm just going to read one of his quotes, and this was given in Vanderbilt, March 21st, 2023, that there's a ton of people with the prior history of voting Democrat in the states and move somewhere do not register to vote. And he goes on to say, then we build a system on how we reach them. We mail them the form, prepaid, pre-addressed, return envelopes that goes right back to their county as trackable. So we can only track their case, but we can call people, follow the doors, and that we can send canvassing messages, texts, and mails and campaigns across the state.
Thank you. And y'all want to wait till the end? Or you have just to clarify something? Okay. Why don't you go on and finish your story?
Excuse me?
I want to hear all of your story.
Yes, go ahead and finish.
Finish the rest?
Yes, your story.
So, it goes on to say that we see how many of them registered and how many turn out to vote, data used to embed messages, canvassing mailers, text campaigns, and looking at everybody who might be on our side. And for me, what I found very interesting is if you go to his website, civitech.com, you can see he gave an example right here of Texas Congressional District 37. And he was able to pinpoint 316,597 Democratic voters that they could target. So we are giving taxpayer money, partisan data, nonpartisan data to this organization that can then transfer it to this other organization. I had a conversation with Jeremy Smith, the owner of the company, of both of them, which is within arm's length and I think is in violation of 271.012. But and I asked him that question, out of $400,000, how much are you actually making? He said, well, we're not very much because most of it's on mailers and sending it out. I said, well, then why are you doing this? What's the reason? Perhaps is it for the data? And he went silent. And so for me, that's the biggest thing for me, what's going on in these organizations, that you had to be extremely careful. The judge in Bexar County, the county judge did not vet it out. We were able to stay one of the county commissioners' vote, but ultimately that judge cited it. He listened to an attorney at Bexar County, which did not have experience in this, and ultimately led to a lawsuit for Bexar County. So that $400,000 that they spent in Bexar County was a heck of a lot more after you add multiple attorneys across the state and across the county.
Thank you. Thank you for your testimony. Lucy, I'm going to introduce yourself and give us your testimony.
Vice Chairman and members. Lucy Trainer, SRC SD 25. This issue came up exactly as Kyle had mentioned.
Can you lean in a little bit more so we can hear you?
Sorry. So this issue had come up in Bexar right after Labor Day weekend of last year. Myself and many concerned citizens were worried about the financial and political motivations behind outsourcing voter registration to civic government solutions. Jeremy Smith, the owner, had claimed nonpartisan roots, but his website told a different story with organizations they had worked with in the past, including Texas, Florida, and Michigan Democrat parties, including the Democrat attorneys general. Jeremy Smith had also stated publicly that his LLC was majority owned by nonprofits who were all progressive political entities. And given this information, we believe that it was impossible to do an unbiased, nonpartisan search with targeting potential voters. Moreover, CGS is an LLC. It's not subject to the same oversight requirements as nonprofits engaged in similar activities. The court itself could not guarantee transparency requirements normally owed to the public with taxpayer money. Further, under the Election Code 276.016, it's unlawful to send out unsolicited applications for ballots by mail. CGS in their marketing materials promoted sending out these applications and had high numbers associated with this activity to promote its business model. In the end, county contracting with this company was a total disregard for Texas law and for the concerns raised by the Office of Attorney General. The voting public had no way to verify if these unregistered voters were in fact citizens on the heels of the November election. At the time, they had to be verified by October 7th, and we knew already that the elections office had basic problems with correcting addresses of people already in the system. Our other concern was that many non-citizens would unknowingly fill out this application and provide false information to authorities facing possible conviction. Lastly, I was here with all of you during the discussion to exit the ERIC contract last session. I would ask that you especially support this bill by prohibiting mini ERICs across Texas, where commissioners' courts may contract with partisan organizations, harvest voter data, and then share it with others for political targeting and partisan voter turnout. Taxpayer money should never be used for these purposes.
Thank you. Thank you for your testimony. All right, one more. Go on and introduce yourself and give us your testimony, please.
My name is Ken Moore. I am for this bill, and I am representing myself. And I hope you don't expect my testimony to be near as spectacular as what you've already heard here. Now, how do you follow this up? But the reason I oppose this, when you start handing things out to people unsolicited, the possibilities for confusion, the possibilities for mistakes, the possibilities for inadvertently breaking the law and finding yourself in trouble for something that you really had no idea what you're signing up for is enormous. Working in polling places, we routinely have people come in to vote a regular ballot and on the machines and say, well, we got a notice here that you requested a mail-in ballot. I said, well, I didn't request anything like that. Well, yeah, they had, but somebody sent it to them and they didn't realize this is a mail-in ballot they're applying for. And so, okay, you have a choice. You can go home and find that ballot and bring it here, or we can give you a provisional ballot. And the possibilities, imagine someone who's not a citizen who gets one of these, and they don't know off the top of their head that they're not eligible to fill this thing out. No one's explained it to them. At least with a VDR, you have someone explaining what you can and can't do. But when you receive something like this in the mail, you may not know these things. And especially true with people who may have issues with English. And so I see all kinds of open doors for mischief with this kind of thing. So I'm asking you to support this bill.
Thank you. Thank you, Mr. Moore. All of you, thank you very much. Members, any questions for the witnesses? Senator Betancourt, you're recognized.
Thanks, Madam Chairman. Kyle, let's go over this to make sure everyone hears this clearly, okay? Basically, what you testified to, and it's pretty shocking, but we heard about it as far away as Harris County. But for once, Harris County was not in the lead, okay? So, Bexar County, they had a contract for about $400,000, and they were going to do 200,000 individual mail pieces, right? Roughly about 50 cents a shot. He did it for cost, right? That's what he told you, because he's really not worried about making money on this. He's worried about mining the data, in my opinion, Now, and then I think you were the one that uncovered the link between Civic Government Solution and civictech.com. So why don't you talk about that again and how the fact that it was effectively co-owned by the same individual?
Yes, sir. Thank you, Senator. It actually started July of 24, and it was a investigative reporter from Texas Tribune that broke the story. And from there, we picked up on it, particularly our county commissioner, Grant Moody, took it and alerted, and from there we started doing a massive grassroots effort, investigating. Once I got involved in it and started learning and seeing the division between Civitech and Civic Government Solution, it was alarming. And from there, I got many involved, from Attorney General Paxton's office to Abbott to U.S. Senate to U.S. Congress to state reps to state senators to get involved. We got the media involved into it to push and to make sure people were doing. The alarming thing was that it was such a blatant lie across the county that many people did not know what was going on, and still to this day, many people do not know that this was going on in the dark of night. This was not about registering voters. I talked to the County Commissioner, Grant Moody, and I'll just throw out some numbers. So CGS registered 959 new voters, of which 677 voted, and they promised thousands of voters. Of that, 569 were duplicate registration, and so there was not what they promised, and so the question begs to ask, what was this for? And it was data. And again, I have evidence of what he is doing on the Civitech side with that information and targeting key races. So absolutely alarming, and I think everybody should know.
Kyle, by the way, this is not your business. You were vice chairman, but you weren't involved in elections. You were just appalled, right?
Correct. I mean, I'm a prior U.S. I was a representative for U.S. Congress in 2022. Currently the vice chair, but my day job, I have a bachelor's and master's in health administration, 20 years of healthcare experience, and I'm a CEO of a hospital. So this is not what I do every single day.
Right. So let's establish the record here, because we're going to have people that question this. They were attempting to, they sent out 200,000 mailers. The end result was 915 people were registered, 677 went to vote, but 569 were duplicate registrations that had already occurred. So when you look at the net of this, okay, of this $400,000 contract, let's see, let me do the math in my head real fast. They registered 363 net people for $400,000. That's not even 0.1% return. That is a horrible waste of taxpayer money, because that's not what this is about from the vendor side, because they can waste that money, and the county commission court wasted. Now, Kyle, would you be surprised to know that I think this technique was pioneered in Travis County, where you're standing?
Absolutely. There's 4 counties. And for me, the concerning thing, we had races in 2024 that were won by hundreds of votes. Hundreds. That's it.
Sure.
And if you have access to 220,000 people, and you can do very targeting messaging, canvassing, door knocking, because you know they didn't vote, you can very much aggressively go after them. That is what is at stake across the state of Texas. That is what's at stake across this nation and going on.
And Kyle, what are the 4 counties that you identified?
I know they tried in Harris. Obviously, it was blocked because of what you
I'm going to get to that as my closing. Don't steal my closing line.
Yeah, so Dallas, Travis, Bexar County was the third one that they got under, and they were talking with Harris County. So those are the 4
that is correct. And Madam Chairman, I want to tell you that they did try to go to Harris County, and actually Commissioner Ellis was in the chamber earlier. He tried to do his best to get them a 4th contract, but through a combination of let's say Attorney General Ken Paxton, Lieutenant Governor Patrick, and myself, we convinced the majority of the board that this would be an instant lawsuit, and that's actually what would have occurred. But it was stopped in Harris County. So for one, Senator Hall and Senator Birdwell, Harris County did not start it, but we did finish it. Yeah, right. Now, this is, and I'll let Lucy and Ken talk about this, just a question of this. this is just absolute taxpayer fraud, right? Because this is a fraud. This is a front company that was getting a contract, sending company information to another company, co-owned by the same person. And I'm going to tell the voter registration stats so Emily will believe that that this was unneeded at the end of this testimony. But Lucy, Ken, you got a comment?
Well, I'd like to add too, just, I don't, if you mentioned this or not, but 200, they reached out, CGS reached out to all of our 254 counties, reached out to all of them. And when you have, when you look on the website, it sounds all very, oh, we just want to get people registered to vote. But when you start digging deeper, it's just a lot more sinister. And all 254 counties were reached out to. They were in active conversations with 40. So this bill will really address having this problem of all these different counties possibly being in conversations and having these mini ERICs. We can't have the problem with ERIC and that contract that we were in was just the giving away of data to help to then go and target voters, and that's exactly what this would do. Now, Bexar County has got all this extra information to then go help them in the 2026 elections.
Ken, a comment?
Well, this is a recurring song that we hear quite often. If you go back to Zuck Bucks, the Zuckerberg bucks that he offered counties, to go out and register people, and you have various organizations that come through every now and again, one to offer money to civic governments to register people, and every session. You'll find a bill that tries to support that. And so far, we've managed to shoot them all down.
Well, just as a comment, Madam Chair, two things. One, there's no opposition to the bill from tax assessor, collectors organization or the administrators because they're going to have their cards out on the counter, just like I did. Let's see, how many years ago now? I don't even want to tell you. They're all, almost 3 decades. And those the cards will be out on the counters, and people will have deputy voter registrars. But what we will not be doing is mailing unsolicited applications to places that have no voter registration. And that's why the net return at Bexar County was less than 0.1%, because they were mailing to unsolicited applications to addresses with no voter registration. And Ken, you're right, causing a lot of confusion on that. And before I yield the floor back, I just want to point out that in November of 22, we had 17.6 million registered voters in the state. But wait, there's more. In November of 2024, we had a record 18.62 million voters in the state, a 1 million increase in voter registration, record increase. Doesn't sound like voter suppression to me is occurring anywhere in the state of Texas. But what it does sound like is that what we're having here is an absolute waste and a fraud of taxpayer money in the guise of registration.
Thank you, Senator Betancourt. Members, any other questions for our panel? All right, thank you. You're dismissed. Well, Senator Hall.
Just one comment. It was mentioned, the issue about mail-in ballots. We have a very similar problem with the mail-in ballot scam, of doing the same thing, of getting mail-in ballots coming back in from people who are on the voter rolls but seldom seldom vote. And so there'd be mail-in ballots coming in from them, and every now and then, one of those mail-in ballots will have been sent to someone who actually shows up to vote, and you find the problem like was discussed up here. But we've got a whole group of folks out there that flies underneath the radar because of that.
Madam Chair?
Senator Hall, what was interesting too is on the thing they mailed out, their support email was not for the county, it was actually for CGS. So it is very alarming that even the support of that ballot, if you had questions, you went to the company, not to the county.
Not unlike the problems we encountered with Eric, which we, thank goodness, got out of.
And Madam Chair, if I could respond. we did manage to stop unsolicited vote applications due to a great lawsuit by Attorney General Penn Paxton, because Harris County started that when they wanted to mail unsolicited early ballot form applications by mail to everyone on the voter roll. I think Chairman Hughes will remember that one because he helped in that as well.
Thank you. Thank you, Senator Betancourt and Senator Hall. We have two more folks to call for public testimony, Taylor Trevino and Luis Figueroa. Taylor Trevino and Luis Figueroa. All right, thank you for coming. We'll start here on the left and introduce yourself and then give us your testimony.
All right, good afternoon. My name is Taylor Trevino. I'm the Voting Rights Senior Advocacy Manager for Texas Civil Rights Project. I'm here today to testify against SB 511. There's multiple reasons that we oppose this bill, but I wanted to highlight one in particular. Restricting the activity of local officials, many of whom are elected, is an infringement on local democracy. When citizens elect their representatives, whether it's their state senator or their county judge and commissioners, they are trusting these officials to make the best decisions for their constituents. With that authority, they identify the needs of their community and act to address them. Strict state voting laws have made it so that everyone must renew their registration when they move a month ahead of an election. And these same strict laws have also made it harder to do so and have contributed to a lack of knowledge around what's required and how to comply. And with busy lives and competing priorities, it's understandable if updating one's voter registration isn't necessarily at the top of the list when they move. If local elected officials deem that it's in the best interest of their constituents to facilitate this process and improve access to the ballot, as with any other issue, we should leave it to them to allocate resources as necessary to address it. There are already mechanisms in place for voters to raise any disagreements they may have with their local elected officials. I urge the committee to leave local issues to local officials and voters and vote no on SB 511. Thank you.
Thank you for your testimony. Please introduce yourself and give us your testimony.
Thank you, Madam Chair. My name is Luis Figueroa. I'm the Chief of Legislative Affairs for Every Texan, and we are in opposition to the Senate bill for three main reasons. Number one, I think it goes to the heart of the role of government here. We believe that local officials and state officials are in the business of informing people about the government services. We do it in a number of situations, whether they're eligible, as long as they're eligible and they can access these services, then I think it's the right and the goal, and in fact, the duty of government officials to inform people about their civic duty to vote and register to vote, and to supply them with the forms to be able to do so. Secondly, we are concerned that the bill is overly broad for the facts that have been laid out. I understand some of the concerns that were laid out by the senator, data mining, not necessarily performing the duties that were called for, some stuff about ERIC. But this bill is really much more broader than that. It basically prohibits anybody from just distributing the form. So even if you put it in a folder at a town hall, or if you're a teacher, if you're, every school is supposed to have a deputy volunteer register. And so they couldn't pass it out unless the student specifically asked for it. We just feel that this bill is much broader than the concerns that have been raised, and the facts don't necessarily match the bill language. And the last concern I have is that the bill is actually aimed at officials, but allows for candidates and political parties. So one, I think it's better to do voter registration as a nonpartisan, so it doesn't appear that you're electioneering and trying to influence people, whereas this bill encourages that kind of electioneering by having the parties and the candidates. And the last concern is there's a very fine distinction between a candidate and an official. So if you are running for office, you're a candidate, but let's say you're a current senator or a current representative that is not running for re-election. Could you not then distribute it because you're now just an official and not a candidate? The line between candidate and official is not always very clear, and I think it's going to lead to a lot of gamemanship of the bill and accusations when someone is running for office that's already an elected official. So for those reasons, we ask you to oppose this legislation and encourage people to do their civic duty and register to vote when they can, assuming they're eligible and the process is fair.
Thank you. Thank you for coming to testify. Members, any questions for our witnesses? All right. Thank you for being here. You're dismissed. And is there anyone else in the chamber wishing to testify on, for, or against Senate Bill 511? Hearing none, public testimony is now closed and the bill will be left pending. Welcome back.
Thank you, Madam Chair.
33, keep it in numerical order.
The chair now lays out Senate Bill 1433, 1433, and recognizes our colleague, Senator Betancourt, its author, to explain the measure.
Thank you, Mr. Chairman. We'll see if we can drive both these bills out by the top of the hour. Concerns have been raised about the Attorney General's ability to assert legislative privilege while representing certain state agencies in court. Senate Bill 1433 allows for the Attorney General to assert legislative privilege on behalf of the state or state agency or official during discovery, hearing, or trial. The Attorney General has 30 days from the date of that legislative privilege asserted to provide evidence of representation to the state or a state agency or official who may properly assert the privilege. SB 1433 provides a provision allowing the Attorney General not to assert legislative privilege if it would create a conflict. We do have Ryan Kelcher from the Chief of Special Litigation as a resource witness to discuss this issue. Happy to answer any questions.
Thank you, Senator Betancourt. Any questions for the author? Very well, we'll open testimony, and the chair calls Ryan Kircher as a resource from the Attorney General's office. If there's anyone wishing to testify on, for, or against Senate Bill 1433, please register outside or come to the table and let us know. Ms. Kircher, welcome. Introduce yourself. Tell us who you represent. We'll have some questions for you.
Thank you very much, Mr. Chairman. My name is Ryan Kircher. I'm Chief of Special Litigation in the Office of the Attorney General. This bill provides line lawyers at the Attorney General's office the important opportunity to preserve the candid conversations that legislators need to have with constituents, experts, concerned members of the community in order to make hard decisions about which policies are best for Texas. It has long been the case that my office, now for more than a decade, has fought very hard to preserve the legislative privilege. As the chairman knows, as Senator Betancourt knows, they both have their names on important Fifth Circuit decisions about legislative privilege. There is, though, in that Fifth Circuit case law, something of a loophole. While the privilege is strong and it covers what we think that it needs to cover, line lawyers in my office do not have the ability or arguably don't have the ability under current Fifth Circuit case law to assert that privilege when it takes them by surprise. So, for example, if we walk into a hearing or a deposition or a trial representing the Secretary of State's office, but a witness begins to get into legislatively privileged conversations, there is an argument that under current Fifth Circuit case law, we cannot assert that privilege and stop that private information from becoming public. What this bill would do is provide line lawyers with the opportunity to assert the privilege and just put a pin in the issue. Keep the matter private until my office gets the opportunity to speak with members to determine whether concerned members want to assert the privilege or waive it. To be clear, this is not some takeover of power. This doesn't give the Office of the Attorney General the opportunity to decide what the privilege is or when, but simply to assert it and then to confer with members to determine whether or not the privilege should hold or be waived. I'm happy to take the committee's questions.
Thank you very much. Senator Betancourt.
Thanks for your testimony. Let's give you this tool. And, Mr. Chairman, it's quite a high honor to be on a, higher level appellate court and higher rulings, as the counselor said, with you, because you're actually the lawyer of the family. I'm just somebody who slept at a Holiday Inn Express last night.
Very kind, Senator Betancourt. Thank you for this bill. Counsel, thanks for walking through this. So let me give you a hypothetical situation that I understand could affect the bill. So, as you say, a hearing or a deposition is taking place, and a question is asked that would or could cover a matter of legislative privilege, maybe a conversation with the witness who's at the hearing and some state representative who's not present and does not have a lawyer present.
That's right.
So far, so good?
Yes.
So in that setting, the AG's office is there, your counsel is there, you have a lawyer there at the deposition in the hearing, and they are not representing that member of the legislature or that member of the executive branch, but the evidence that could be coming up could be subject to a privileged, might be a conversation between the legislator and this witness that's a privileged conversation. So under this bill, the Attorney General's office can raise that privilege even though they don't represent the person who might be involved in the conversation. Is that the idea?
That's exactly right, Mr. Chairman. And to be clear, the hypothetical could be even broader. So I'll give you an example of a case that did not involve the assertion of legislative privilege, but could have. A couple of sessions ago in 2021, the legislature passed SB 315, which was a bill that raised the minimum age to work in sexually oriented businesses from 18 to 21. A part of that First Amendment analysis, because that bill was challenged by a variety of sexually oriented businesses, was what it was designed to stop, what it was designed to regulate. Was it designed to regulate protected First Amendment speech, or was it designed to regulate secondary effects of First Amendment speech, specifically human trafficking? We looked very closely at the legislative record in that case. Fortunately, that record was robust and did not require testimony from senators or other members or folks who had spoken with senators. We were able to do that just on the paper. But we had a preliminary injunction hearing, we had multiple depositions, and we had a trial. And at any one of those places, a witness, whether a member or not, could have said, oh, well, I spoke with Chair Paxton, I spoke with Chair Hughes about this, and they didn't care about human trafficking. They only cared about whether or not strippers can take their clothes off. Under current case law, there is an argument that because I represented in that case no members, but only state agencies and officials who were not members, that had I said, objection, legislative privilege, do not answer the question, that I might not have been able to stop that privileged information from becoming public. This bill provides a tool that says, I don't get to decide what the privilege is. I don't get to decide for members whether to invoke or waive the privilege. I just get to, in the moment when it might be made public, before a member has had the opportunity to choose to waive the privilege, that it will stay private until a member can make that choice.
Thank you for that. And while we're on this topic, and get a little closer to the microphone too as you answer it, thank you for your testimony. Just for those that may not be familiar with legislative privilege, tell us how it works and why. Because it's not to protect members of the legislature, it's to protect the legislative process so that the public is represented. But help us understand why we have that privilege and how it works.
So there are two main reasons behind the legislative privilege. One is to protect the legislators and members of the community who work with members on legislation, on these hard, knotty policy issues where the conversation has to be candid. No one should be afraid to ask a difficult question in those conversations for fear that they might have to explain that question later on in court. The other function of the legislative privilege is so that legislators don't get pulled out of their important legislative obligations so that they have to go and testify all the time in the litigation that particularly my office and my division is involved in, defending the good laws passed by the legislature.
And thanks for your testimony. Members, any other questions for the witness? Thank you for being here. Is there anyone else present wishing to testify on, for, or against Senate Bill 1433? To be clear, the floor is still open for public testimony. Anyone wishing to testify on, for, or against Senate Bill 1433? Seeing and hearing none, public testimony is closed. Bill's left pending at this time. The chair now lays out Senate Bill 1434. 1434 recognizes its author, our colleague Senator Betancourt, to explain the measure. Senator.
Thank you, Mr. Chairman. Members, just unamas for everyone's patience. One more here. Senate Bill 1434 codifies an Attorney General's opinion request from 2018. I think Senator Middleton will remember this. It bans the use of public funds to transport district students or employees to or from a building or location selected as a polling place under the election code on the day of election or while early vote is in process. However, this would not apply to the transportation of students to or from their regularly scheduled attended campus or school-sponsored activities such as a field trip. Happy to answer any questions.
Thank you, Senator Betancourt. Members of the committee, any questions for the author on Senate Bill 1434? Very well. Public testimony is now open. And the chair calls James Quintero, Emily French, Ken Moore. Looking for James Quintero, Emily French, and Ken Moore. Those are the three witnesses who have registered to testify on, for, or against Senate Bill 1434. If there's anyone else present wishing to testify on, for, or against Senate Bill 1434, please come down and let us know. It looks like we have Mr. Moore, Mr. Quintero still looking for Emily French, if she's still present, wishes to testify. And we will go ahead and get started. Mr. Moore, welcome back. Introduce yourself, give us your testimony.
Yes, sir. My name is Ken Moore. I am for this bill, and I'm representing myself. When you get to the business of transporting people, you put yourself in a situation where you can skew the electorate in a certain direction. Several years ago, there was an Alan Vera story. We had a mayoral candidate in Harris County, I won't say who it was, that came in and he was sending out these buses to homeless shelters and bringing them in to vote. And they would offer them, maybe a bottle of wine or something. One of my election clerks that I routinely used was in one of the polling places, and she reported that many of these people came in, they really had no idea what they're voting for, but that somebody picked them up and told them to go vote. Now, I don't expect school children to come in, with issues like that, but when you start targeting demographics and saying, we're going to go pick these people up and we're going to take them to the polling place, you do open it up to skewing the election towards a certain demographic and a certain class of people. There's wisdom in not having school buses do this. I think this is a good bill, and I urge you to pass it.
And thanks for your testimony. Mr. Quintero, welcome. Introduce yourself and go ahead.
Yes, sir. Mr. Chairman, members of the committee, my name is James Quintero. I represent the Texas Public Policy Foundation. And I want to thank the committee for taking up this measure today as it's focused on targeted election integrity. I'm here to testify in support of SB 1434. During the prior interim, an alarming number of school districts were alleged to have engaged in electioneering. In fact, during the spring 2024 election cycle, the Texas Attorney General's office indicted 7 ISDs over possible violations of the education and election codes. Now, while none of these instances necessarily involved busing employees to the polls, I'd say that this spate of illicit activity has corroded public trust, and I believe that this bill is necessary to restore confidence in school district election outcomes. But if you're interested in an example of ISDs busing employees to the polls, what you'll see in your handout is one instance in particular involving South San Antonio ISD. And in the article, what you'll see is that South San Antonio ISD in 2018 held a $6.3 million tax ratification election wherein the only polling locations were located at South San Central Administration Building and South San High School. Now, because of perhaps the August timing or the limited number of polling locations, turnout for the election was rather small. So what the district did in response is it began busing its employees to the polls on election day using taxpayer-funded transportation. This, of course, drew some attention from the Texas Attorney General's office, which the bill author has already mentioned. While this involvement of the Texas AG is a positive development, I suggest that we could benefit from new statute that expressly prohibits this type of activity. In so doing, we might restore public trust and return ISDs to their core mission. For that reason, I humbly ask you to pass Senate Bill 1434. Thank you for your time.
Thanks, Mr. Quintero. Ms. French, welcome back. Remember, on the end, get a little closer and go ahead and introduce yourself. Give us your testimony.
Yes, sir. I'm doing every microphone today, I think. My name is Emily Evie French. I'm testifying on behalf of Common Cause Texas. We are here in opposition to SB 1434. American school kids are getting less and less education about their government. The Sandra Day O'Connor Institute for American Democracy noted that until the 1960s, American public high school students were typically required to take 3 courses in civics. Today, most students only take a single semester-long class in government. Multiple studies have shown that older Americans are significantly better informed about civics than their younger counterparts. A study from the mid-1990s revealed that the civics education of high school graduates at that time was comparable to high school dropouts in the late 1940s. One of the most important ways that we can make up this gap and get kids invested in civic education is by having them see it in action. Countless schools make field trips to this very Capitol for that purpose, but many can't afford to travel to the Capitol. On the other hand, every single school in Texas is within a reasonable driving distance of a polling place. If we prohibit schools from taking students to witness voting in action, we're cutting off one of the most affordable, accessible ways for kids to get involved in democracy. We're not opposed to rules surrounding schools and polling places. We're not opposed to rules to ensure that school visits to polling places are not disruptive, which I know was part of the Attorney General's thoughts as well. But banning these visits altogether is not good practice for the health and future of our democracy. So we oppose the bill. Thank you.
And thank you for your testimony. Senators, any questions for any of our witnesses on Senate Bill 1434? Senator Betancourt.
Just to, James, there's obviously more bills coming, but I think just a minute of elaborating, we had about 7 school districts, I think, that were substantially engaged in electioneering, and I believe the Attorney General had sued either 6. I can't remember at last count, but you want to give a quick summary of that, just to reemphasize that point of your testimony?
Yes, sir. In fact, during the interim, I authored a paper called Thumb on the Scale, looking at ISD electioneering over the last year. With respect to the spring elections in particular, there were 7 districts that the Attorney General's office went after. Those included Aledo, Castleberry, Denison, Denton, Frisco, Huffman, and Hutto ISDs. All of those were accused of, I would say, some fairly egregious activity. And again, it's not necessarily related to busing in particular, but it does suggest a rather bad environment. And in that type of environment, I think we need to put in place some strong protections to make sure that election integrity is respected and that the will of voters in particular is held true. So I want to thank you for your measure because I think it will take us in the right direction.
Thank you, Senator Betancourt. Members, any other questions for our witnesses? Very well. Thank you each for being here. You're excused.
Thank you.
Is there anyone else wishing to testify on, for, or against Senate Bill 1434? Seeing and hearing none, public testimony is closed. The bill will be left pending at this time. Senators, we will take up some pending matters at this time. We are not voting on any of the bills that were heard today. We're voting on bills that we have previously heard and had some time to look at. The chair lays out as a matter of pending business Senate Bill 965. 965 by our colleague Senator Parker. That's the bill about public school employees engaging in religious speech or prayer while on duty. Senator Hall moves that Senate Bill 965 be reported favorably to the full Senate with the recommendation that it do pass and be printed. Will the clerk call the roll?
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Schwertner, Zaffarini, Paxton, Hughes.
Aye. There being 8 ayes and no nays, Senate Bill 965 will be reported favorably to the full Senate. Senator Betancourt moves that Senate Bill 965 be certified and recommended for placement on the local and uncontested calendar. Is there any objection? Hearing none, it is so ordered. Got that local? Yep. The chair lays out as a matter of pending business Senate Bill 985 by Betancourt. That's Senator Betancourt's bill about the combination of certain election precincts, unfinished business from last session. Senator Parker moves that Senate Bill 985 be reported favorably to the full Senate with the recommendation that it do pass and be printed. Will the clerk call the roll?
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Schwertner, Zaffarini, Paxton, Hughes.
Yes. There being 8 ayes and no nays, Senate Bill 985 will be reported favorably to the full Senate. Sound like a local and uncontested bill? Y'all, Paul? Let's see if does Paul want it on. He can pull it off. He can pull it off again. Senator Birdwell moves that Senate Bill 985 be recommended and certified for local and uncontested. Is there objection? Hearing none, it's so ordered. Thank you. The chair lays out as a matter of pending business Senate Bill 509 by Senator Betancourt. 509. Senator Hall moves that Senate Bill 509 be reported favorably to the full Senate with the recommendation that it do pass and be printed. Will the clerk call the roll?
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Schwertner, Zaffarini, Paxton, Hughes.
Yes. There being 8 ayes and no nays, Senate Bill 509 will be reported favorably to the full Senate. Senator Parker moves that Senate Bill 509 be certified and recommended for placement on the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. The chair lays out as a matter of pending business Senate Bill 406 by Senator Middleton. Senator Hinojosa moves that Senate Bill 406 be reported favorably to the full Senate with the recommendation that it do pass and be printed. Let me pause just for a moment before I complete that motion. There was a discussion about a committee substitute. We want to be clear. We're voting on the bill as filed, as presented to the committee, not a committee substitute. Is that right, Senator? And I should have clarified that. So let me make that motion again. Senator Hinojosa moves that Senate Bill 406 be reported favorably to the full Senate with the recommendation that it do pass and be printed. Will the clerk call the roll?
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Schwertner, Zaffarini, Paxton, Hughes.
Aye. Yes, there being 8 ayes and no nays, Senate Bill 406 will be reported favorably to the full Senate. That's probably going to end up on the floor, I would think. Okay, all right. Very good. And the chair lays out as a matter of pending business Senate Bill 875 by Senator Birdwell. Senate Bill 875 by Senator Birdwell. And this is not a committee substitute. This is the bill as filed, as presented, Senate Bill 875. And Senator Hall moves that Senate Bill 875 be reported favorably to the full Senate with the recommendation that it do pass, be printed and placed on the Senate calendar. Will the clerk call the roll?
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Schwertner, Zaffarini, Paxton, Hughes.
Aye. There being 9 ayes and no nays, Senate Bill 875 will be reported favorably to the full Senate. And that's going to the floor because you have a floor amendment. Okay, very well. The chair lays out as a matter of pending business Senate Bill 447 by Senator Hinojosa of Hidalgo. Senate Bill 447. And Senator Betancourt moves that Senate Bill 447 be reported favorably to the full Senate with the recommendation that it do pass and be printed. Will the clerk call the roll?
Betancourt. Aye. Birdwell. Hall. Aye. Hinojosa. Middleton. Parker. Perry. Schwartner. Aye. Zaffarini. Paxton. Aye. Hughes.
Yes. There being 9 ayes and no nays, Senate Bill 447 will be reported favorably to the full Senate. Senator Betancourt moves that Senate Bill 447 be recommended and certified for placement on the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. The chair lays out as a matter of pending business Senate Bill 893. That's our colleague Senator Johnson's bill about distributing certain misleading images and videos. Senator Johnson has previously explained to us the committee substitute. So the chair sends up the committee substitute, Senate Bill 893. Senator Parker moves that we adopt the committee substitute. Is there objection? Hearing none, the substitute is adopted. It is now before us. Senator Parker moves that Senate Bill 893 as substituted be reported favorably to the full Senate with the recommendation that it do pass and be printed. Will the clerk call the roll?
Betancourt. Aye. Birdwell. Aye. Hall. Aye. Hinojosa. Aye. Middleton. Aye. Parker. Aye. Perry. Schwartner. Aye. Zaffarini. Paxton. Hughes.
Yes, there being 9 ayes and no nays, Senate Bill 893 as substituted will be reported favorably to the full Senate. Senator Parker moves that Senate Bill 893 as substituted be recommended and certified for placement on the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. The chair lays out as a matter of pending business Senate Bill 1539 by Senator Betancourt. 1539. Senator Birdwell moves that Senate Bill 1539 be reported favorably to the full Senate with the recommendation that it do pass and be printed. Will the clerk call the roll?
Betancourt. Aye. Birdwell. Hall. Aye. Hinojosa. Middleton. Aye. Parker. Aye. Perry. Schwartner. Aye. Zaffarini. Paxton. Aye. Hughes.
Yes. There being 9 ayes and no nays, Senate Bill 1539 will be reported favorably to the full Senate. Senator Parker moves that Senate Bill 1539 be recommended and certified for placement on the local and uncontested calendar. Is there objection? Hearing none, it's so ordered. As a matter of pending business, the chair lays out Senate Bill 987. 987 by Senator Betancourt. 987. And Senator Birdwell moves that Senate Bill 987 be reported favorably to the full Senate with the recommendation that it do pass and be printed. Will the clerk call the roll?
Betancourt. Birdwell. Hall. Hinojosa. Middleton. Parker. Perry. Shortner. Zaffarini. Paxton. Hughes.
Yes, there being 9 ayes and no nays, Senate Bill 987 will be reported favorably to the full Senate. Do you want that on the floor? Was it? Very well. Very good. Thank you. And I'll pass the gavel to the Vice Chair to consider votes on some bills that I had presented to the committee.
The chair brings up Senate Bill 810. 810 by Senator Hughes relating to the protection for a public school employee's use of terms consistent with biological sex. Senator Hinojosa moves that we report Senate Bill 810 favorably to the whole Senate. The clerk will call the roll.
Betancourt. Birdwell. Hall. Hinojosa. Middleton. Parker. Perry. Shortner. Zaffarini. Paxton.
Aye.
Hughes.
Aye.
The votes being 9 ayes and 0 nays, Senate Bill 810 will be reported favorably to the whole Senate.
Thank you.
You're right. Okay. Okay. All right. Thank you. Chair lays out as a matter of pending business Senate Bill 1073 by Senator Hughes relating to the discrimination or burdening of certain constitutional rights of an applicant for or holder of a license to practice law in this state. Senator Birdwell moves that Senate Bill 1073 be reported favorably to the full Senate with recommendation that it do pass and be printed. The clerk will call the roll.
Betancourt. Birdwell. Hall. Hinojosa. Middleton. Parker. Perry. Shortner. Zaffarini. Paxton.
Aye.
Hughes.
Yes.
The votes being 9 ayes and 0 nays, Senate Bill 1073 will be reported favorably to the full Senate. Okay. All right. Chair lays out as a matter of pending business, Senate Bill 1119 by Senator Hughes relating to a liability of a water park entity for injuries arising from certain activities. Senator Parker moves that the bill be reported favorably to the full Senate with the recommendation that it do pass and be printed. The clerk will call the roll.
Betancourt. Aye. Birdwell. Hall. Hinojosa. Middleton. Parker. Perry. Shortner. Zaffarini. Paxton.
Aye.
Hughes.
Aye.
There being 9 ayes and 0 nays, Senate Bill 1119 will be reported favorably to the whole Senate. Want to do local on that? Okay. Senator Hughes moves that Senate Bill 1119 be recommended and certified for placement on the local and uncontested calendar. Is there objection? Hearing none, it was so ordered. Chair lays out as a matter of pending business Senate Bill 689 by Senator Hughes relating to the implementation of diversity, equity, and inclusion initiatives by certain governmental entities. Senator Betancourt moves that the bill be reported favorably to the full Senate with the recommendation that it do pass and be printed. The clerk will call the roll. There's a committee sub. Members, we're going to leave Senate Bill 689 by Senator Hughes pending. Chair lays out as a matter of pending business Senate Bill 1220 by Senator Hughes relating to the subject matter jurisdiction of the criminal trial courts of this state. Senator Middleton moves that the bill be reported favorably to the full Senate with recommendation that it do pass and be printed. The clerk will call the roll.
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Shortner, Zaffarini, Paxton,
Aye.
Hughes.
Aye.
There being 9 ayes and 0 nays, Senate Bill 1220 will be reported favorably to the full Senate. Senator Hughes moves that Senate Bill 1220 be recommended and certified for placement on the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. Chair lays out as a matter of pending business Senate Bill 1033 by Senator Hughes relating to the withdrawal of a candidate in a runoff primary election. Senator Hall moves that the bill be reported favorably to the full Senate with the recommendation that it do pass and be printed. The clerk will call the roll. This is Senate Bill 1033.
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Shortner, Zaffarini, Paxton,
Aye.
Hughes.
The votes being 9 ayes and 0 nays, Senate Bill 1033 will be reported favorably to the whole Senate. Okay. Senator, who are you? Betancourt, right? Senator Betancourt moves that Senate Bill 1033 be certified and recommended for placement on the local and uncontested calendar. Is there objection? Hearing none, so ordered. All right. The chair brings up Senate Bill 1346 by Senator Hughes as a matter of pending business. There is a committee sub, and you're recognized to explain the committee sub.
Thank you, Madam Chair. Members, you'll recall this is one of the many lottery measures we're considering this session. This is about when folks try to buy up all the tickets. We were reminded that you can buy substantially all the tickets and pretty much get the same effect. And so the committee substitute clarifies that it's not just persons attempting to buy all possible winning combinations, but trying to buy substantially all winning combinations. That's important language. That's what the committee substitute does. It effectuates the original purpose of the bill, and I ask for your favorable consideration.
Thank you, Mr. Chairman. Members, any questions on the committee substitute? All right. Senator Hall moves that we adopt the committee substitute. Is there any objection? If not, the substitute is adopted. Senator Hall moves that we report the committee substitute to Senate Bill 1346 favorably to the whole Senate, with the recommendation that it do pass and be printed. The clerk will call the roll.
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Shortner, Zaffarini, Paxton,
Aye.
Hughes.
Aye.
Had to think about that a little bit. All right. The votes being 9 ayes and 0 nays, the committee substitute to Senate Bill 1346 will be reported favorably to the whole Senate. Local? Okay. Senator Hughes moves that committee substitute to 1346 be recommended and certified for placement on the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. Chair lays out as a matter of pending business Senate Bill 1362 by Senator Hughes relating to prohibiting the recognition, service, and enforcement of extreme risk protective orders and creating a criminal offense. Senate Bill 1362. Senator Middleton moves that we report Senate Bill 1362 favorably to the whole Senate with the recommendation that it do pass and be printed. The clerk will call the roll.
Betancourt. Aye. Birdwell. Hall. Hinojosa. Middleton. Parker. Perry. Shortner. Zaffarini. Paxton.
Aye.
Hughes.
Yes.
There being 9 ayes and 0 nays, Senate Bill 1362 will be reported favorably to the whole Senate. Local? Okay. The chair lays out as a matter of pending business SCR 22 by Senator Hughes, designating the cannon as the official state gun of Texas. SCR 22. Senator Betancourt moves that we report. Senator Birdwell, you are recognized. So we can hear you.
May I ask preference to be shown as for the record as the individual sending this bill up, given my history and past proclivities with such weapons?
I do believe you are the most experienced member of this committee.
I reserve the right to move local.
All right. Senator Birdwell moves that we report SCR 22 by Senator Hughes favorably to the whole Senate, with the recommendation that it do pass and be printed. The clerk will call the roll.
Betancourt. Aye. Birdwell. Hall. Hinojosa. Middleton. Parker. Perry. Shortner. Zaffarini. Paxton.
Aye.
Hughes.
Yes.
All right, the votes being 9 ayes and 0 nays, SCR 22 will be reported favorably to the whole Senate. Senator Hall, did you and Senator Birdwell want to arm wrestle or anything over rights to do something on this bill? I don't know. No? All right. All right, Senator Betancourt moves that SCR 22 be recommended and certified for placement on the local and uncontested calendar. Is there objection? Hearing none, it is so ordered. Welcome.
Mr. Chairman, I have one request.
Thank you, Mr. Chair. Recognize Senator Betancourt. Sir?
If you do bring that bill back to the floor, could we have a demonstration?
Oh, that's a great idea. Thank you, Senator. And for those who may be looking at the agenda, Senate Bill 1386 was posted for today. That at the request of the author, that bill was not heard. It'll be left pending, and we will be hearing that bill in the future. A little more work on that bill. Is there anything else to come before the Committee on State Affairs at this time? We have motions in writing from members requesting that their positions be shown. Without objection, those will be adopted. And with that, we thank the Senate team that worked so hard to have to put the tables in and back and in and back and get all the sound working and to keep the video going and everybody safe and at the right place. I'm thankful for each member, for your staffs, for our committee staff and my team. And so with that, the Committee on State Affairs stands in recess, subject to the call of the chair. Good afternoon.